like to mention item 16 of today's list. Lordship. The other side is here. Lordship, let it be taken up any other day. I am a new engaged counsel on behalf of AIDC.
Item number 16.
16. The other side is here.
Mr. What is the
A.
name?
Kakoti.
A. Kakoti. Learned counsel appearing for the respondent submits that he has been newly engaged by the respondent to appear in this case. Hence, he prays for an adjournment. The prayer is not opposed to by the learned counsel for the appellant. Hence, same is allowed. Let this matter be listed after a week on a date to be fixed by registry.
Well, in the IML, there is an interim. That may be
In the IA, the interim order shall continue till next day.
much.
Obliged, Lordship.
Well, up to MSc appeal pending here with this honorable court. It was last listed in one Malad India 2023, another 22. One is death case, another is injury case.
Orders column.
Orders column. 31st.
Oh no, court number 8 you have to. mention.
With this, Your Lordship. Lordship, I beg to mention item number 14. Lordship, CD is not there.
They are on interim also. Lordship.
3D is not there. What is your name?
Sulia Chumi.
Miss Sulya Chumi, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor, who prays for some more time for production of the case, and the prayer is allowed. Let this matter be listed on 10th of September. The interim order shall continue till next day.
Please, Lordship. Lordship, I beg to mention for the matter for urgent listing, CRP-IO on tomorrow, Lordship.
Court number? Court number 8. Go to court number 8. Senior court is there. You have to make mention before that court.
Lordship, I in MSc appeal, Lordship, for delay for in orders for me.
Court number 8.
Therefore, listing on date petition. Lordship, the matter was last listed on 1/6/2020.
What writ petition?
Bank account defeats.
Go to proper court. This court is not taking up those matters.
I do.
Item 61 to
May I please, your Lordship. Lordship, this petition is under Article 227 against the orders passed by the Learned Civil Judge Senior Division number 1, Gauhati, Lordship. The fact of the case is this, Lordship, Assam Sahitya Sabha is a literary organization of the Assam and one of the oldest organization of Assam, your Lordship. What happened, Lordship? The respondent plaintiff filed a title suit, Lordship, for declaration and permanent injunction, and praying therein permanent injunction, restraining the present petitioners from holding the conference, that is the Pratinidhi Sabha in Golaghat, which was fixed on 7th of June 2026. The learned trial court, without going through the plaint was admitted and did not care to see that the suit has been filed in a representative capacity, and it was the duty of the respondent plaintiff to take leave from the court by filing an application under Order 1, Rule 8 of the CPC. That was not done. Your Lordship, may please to come to the order.
Page number?
Didn't admit renewal. What is this?
Page 46, Lord. Page 46, Lordship, Annexure 2. This is the first order passed by the Learned Trial Court on 25th of May to 26. Case record is received on transfer for disposal. Peruse the plaint along with the accompanying documents. Plaint is filed in duplicate along with the adequate court fee. This is a suit for declaration and permanent injunction. The plaint is admitted petition filed by the petitioner under order 39 rules 1 into redo section 151 of the CPC is registered as J case number. Issue summons to the defendants fixing 16/12/26 for SRWS. So the plaint was admitted and summons were issued. Now, your lordship, will please put plaint. Where is the plaint? 29.
Have you appeared?
Lordship,
Have you appeared before the trial court?
I have.
You have
The
appeared?
other learned counsel has it, not mine.
No, whether the,
Defendants are appeared. Defendants have appeared, they filed the application under order 7 rule 11 for the rejection of the plaint. Objection was also filed against the injunction petition. Some strangers, when come to know who are the members of the Sahit Sabha Lordship, file an application for impleadment as plaintiff or defendant by filing application under order 1 rule 8. Nothing was considered by the learned trial court law. And now, your lordship, will please to page, come to page
29, plaint, no?
20.
29. Next one.
Page 20, next one. This is the plaint, lordship. Here the defendant number 1 and 2 are the president secretary, then your lord, other branches of the Assam Sahit Sabha up to defendant number 9 were impleaded, lordship. And lordship, we please to come to the para 17 of the plaint. Page 39, lordship. Page 39, lordship. From the bottom 2 lines, lordship. From the bottom 2 lines. However, notwithstanding the letter, the president and the secretary of the Assam Sahit Sabha have illegally persisted in their attempt to amend the constitution with ulterior motive, which is deeply unfortunate for the people of Assam and the members of the Assam Sahit Sabha. This shows that this suit is in a representative capacity. Then, your lordship, may please to come to the para 18, bottom, lordship, same page, lordship 40, the bottom. The defendants are therefore liable to be permanently restrained by way of injunction from giving effect to of the proceeding with the holding of the Pratinidhi Sabha. Pratinidhi Sabha scheduled on 7/6/26 at Golaghat under the Golaghat Jilla Sahitya Sabha, as well as from giving effect to the Adorni Samiti constituted for the said purpose. Then para 19 is important, lordship. That the plaintiff begs to state that the defendants are powerful and power-hungry persons who, driven by their adamant stance and self-interest, are proceeding to hold the Pratinidhi Sabha on 7/6/26 in a flagrant violation of the laws, rules, and the regulations of the Constitution of the Assam Sahit Sabha. If the defendants are not restrained by granting of a permanent injunction, the plaintiff as well as the people of Assam and the members of the Assam Sahitya Sabha will suffer irreparable loss and injury, and the glorious reputation of the Assam Sabha as a prominent culture and literary organization of the state will be irrevocably damaged. This also shows, lordship, para 19, that this suit has been filed in a representative capacity without taking leave as required under order 1 rule 8 of the CPC and without filing any application as required under section order 1 rule 8 of the CPC, your lordship. Lordship, I have quoted the provisions of the order 1 rule 8 in my petition. Your lordship will please to take up the CPC.
no, which order you are impugning?
Pardon.
Which order you are impugning?
3 orders were in.
3 orders we have told. First, when the plaint was admitted, lordship, because your lordship is well versed that in case of a rejection of the plaint, other documents cannot be looked into. Only the averments made in the plaint will be looked into. Same is the case, lordship, in case of a order. If there is a suit in a representative capacity, no need to go through the any other pleadings except the averments made in the plaint will be considered that whether if the suit is in a representative capacity or not. In the present petition, lordship, I have also quoted the provisions of order 1 rule 8 of the CP. Kitna page mein? Lordship, may I please to come to अरे क्या तो पेज बोलो
17. 17.
हाँ, page 17, lordship. Page 17, lordship, para 25.
Where is order dated 5/6/26?
Yes, 5/6, lordship. 5/6 वाला का है।
182.
182, lordship.
Next to 15.
Hmm?
Next to 15. Objection is plain color.
This is lordship 5/6/26, lordship. Lordship, some of the strangers were not the parties. They had filed the application under order 1 rule 8, and also some of the defendants had filed application under order 7 rule 11 for the rejection of the plaint. So this order relates to that. Both the parties are represented. The case is fixed for order on maintainability of the suit. 3 petitions have been filed by the defendant number 1, 2, and 3 have filed their petition number so and so under order 7 rule 11 of the CPC, read section 9 and 151 of the CPC, and the defendant number 4, 5, and 6 have filed petition number so and so under order 7 rule 11 of the CPC, read with section 9 and 151 of the CPC. The defendant number 7, 8, and 9 have also filed petition number so and so under order 7 rule 11 of the CPC, read with section 9 of 151 of the CPC. Learned counsel for the plaintiff has not filed any written objection due to paucity of time and has advanced his argument verbally. Prior to decide the merit of the said petition, I want to deal with the issues raised by the counsel.
Okay,
for
we will issue notice.
Pardon?
We'll issue notice.
Notice, lordship, in the meantime, lordship, the impugn order may be stayed.
Which impugn order? Which impugn order?
Interim order, lordship, the learned trial court had granted injunction restraining the petitioner, lordship, from holding the Pratinidhi Sabha meeting at Golaghat, lords. Your lordship, please,
On a particular date, that date has already lapsed.
date has already, but your lordship, the suit is not maintainable.
That we will examine. That we will examine. Whether suit is maintained.
No.
Mr. Mehdi, you are appearing for
The
in
suit
person.
may be stayed, lordship. Further proceeding may be stayed.
May I please, my lord, I have some.
No, I have to submit. I have not finished.
No, we are issuing notice.
Lordship has delivered a recent judgment on order 1 rule 8 in the month of June, which has been reported, lordship. There your lordship held that the taking leave is required under
When
order
is the next? When is the next?
is mandatory.
No,
Is
no.
mandatory.
When is the next date in this suit?
Next day 31.
30%.
30.
Till then, further proceeding,
31?
August.
Oh, date is fixed for what?
It's for objection, and WS. They are not filing the WS, my lord.
For filing of WS.
For filing, why I should file W, lordship, when the suit is not maintainable? So till next date, further proceeding of the suit may be stayed.
No, what further proceeding? It is fixed for WS, filing of
But
WS.
WS,
You can take that plea in WS also.
no, also, hearing some strangers have filed application for imprisonment. So that hearing is also fixed on that day
For impleading.
for objection and objection here.
On impediment petitions.
This is a fit case, Lordship. Your Lordship,
No, let the other side appear.
other side has appeared.
Only one has appeared. There are other.
Only one plaintiff. My
But
learned
you-
friend is appearing in person. My learned
No,
friend has filed this.
But you have made only one.
No, only there is only one plaintiff. Single sole plaintiff.
My lord, I have filed this case in my own capacity. My lord, as a person, I have appeared before this court, my lord.
Are you a member of Assam
Yes, my
Sahitya?
lord.
Yeah, he is.
I am a member of the Assam Sahitya Sabha, a life member and as well as a Hitoshi member of the Assam Sahitya Sabha. Since 1987, my lord. I was a legal advisor of the Assam Sahitya Sabha also. They are going to hold a meeting illegally and unlawfully. That's why I am filed this suit. My lord, my learned friend stated that I am not following the order rule 8, my lord. So I rely on decision of the apex court.
No, before that. Which order you are impugning? The order of rejection of your order 7 rule 11 petition.
They challenged the 3 orders, my lord.
There are 3 orders, Lordship. No objection was filed by learned friend. Even the learned trial court,
What are those 3 orders?
same.
First order, title suit, first order.
First order is in the title suit, Lordship, and
Admitting the plaintiff.
admitting the plaint, Lordship, that we have challenged.
Second
That is
order,
Getting of plaintiff.
rejection of the plaint order 7 rule 11 petition.
third order.
That or third order is the injunction order, which has been-
Injunction you have to, this is not maintainable.
Pardon.
227 is not maintainable against injunction order.
Yes, Lord.
You have to come under order 43 rule 1R.
No, Lordship, when the court does not have the jurisdiction to enter the suit, then 227 is maintainable, Lordship. 227, because even the learned trial court has no power to issue summons to the defendant, Lordship. I am having the judgments of the apex court as well.
No, that contention you have raised, that needs to be examined.
Lordship, if the learned trial court has no jurisdiction to enter the suit, no jurisdiction to
Yeah.
issue the summons,
And
Lordship.
that we will examine, whether the court has jurisdiction or not.
That's why, Lordship.
Whether is it a representative suit or not, that is the question needs to be
No,
decided.
Okay, no, I have nothing to, Lordship, till then the further proceeding may be such. Title suit. This is a fit case, otherwise I may be heard, Lordship. There are 9-10 judgment of this High Court, Lordship, as well as the Supreme Court judgment. Your Lordship judgment is of June 2026.
You will be filing any written objection?
Yes, my lord, I will file.
When?
Even 15 days minimum, my lord.
File before 31st.
31st, it is not possible because they are in the case, my lord. That case I will appear.
No, or we will stay that case, then you appear before
That
this.
case is for document and objection, my lord.
Therefore, I am saying
Objection and hearing.
you
both.
file your written objection by by 28th of August.
My lord, the first week of September, I will file.
Then we have to stay the suit.
No, my lord, I have objection to stay the orders, my lord.
I am
If
not
you
praying
order
for
to
a stay of any order, Lordship. I am
My-
praying for further stay, to stay the further proceeding of the suit.
Then, my lord, matter will be infectious, my lord, if he stays
This
order passed
suit
by the
itself-
court, my lord.
Then you file objection by 30.
Yes, my lord, I'm at right.
Then we will decide the matter on 30. Let him file objection.
Okay,
Because next date is on 31st.
yes. Yes,
So let him file before on 28th of August.
30 I will file.
No,
Lordship-
30 is holiday.
Lordship, may be pleased to consider one point. If the contention of order 1 rule 8 is decided only on the basis of the averments made in the plain, What is the need of filing the objection or affidavit in apply? I fail to
No,
understand.
let him file objection. We'll decide it before next date. Heard.
Suit I have filed in my own capacity, my lord. I am not
We will decide that.
file the suit for all.
Heard, Mr. S.P. Roy, the learned counsel for the petitioner. Also heard, Mr. A.R. Medhi. Mr. A.R. Medhi, the respondent appearing in person. This application under Article 227 of the Constitution of India has been filed by the petitioners impugning the orders dated 25/5/2026 passed by the Court of Learned Civil Judge Senior Division Kamrup Metro entitled suit number 328/2026 issuing by which the summons were issued to the respondents, to the defendants in the said suit. Stop. The petitioners have also impugned the order dated 5/6/2026 passed in the above mentioned suit by the Court of Learned Civil Judge Senior Division, whereby the petitions filed by the respondents under Order 7, Rule 11 for rejection of claim was dismissed. The petitioner,
Filed by the petitioner lordship, not by respondent.
yes, sorry, filed by the petitioners was dismissed. The petitioners have also impugned the order dated 6/6/2026 passed in Ms. J case number 599/2026, whereby the petitioners were restrained from holding the Pratinidhi Sabha of the petitioners organization on 7/6/2026 at Golaghat. The main plea of the petitioners in this case is that suit filed by the present respondent is a representative suit, however, no prior leave of the court was sought for by the respondent under Order 1, Rule 8 of the Code of Civil Procedure 1908 prior to filing of the said suit. Hence, it is contended by the petitioners that the suit filed by the present respondent is not maintainable. Stop. The respondent appearing in person has prayed for some time for filing written objection against the petition filed by the petitioners. Whereas learned counsel for the petitioners have prayed for staying the further proceeding of the title suit number 328/2026 as the question of maintainability of the suit has been raised in this revision petition. Stop. Since next date fixed before the trial court is on 31st of August, let this matter be listed again on 28th of August. 28th of August, by which date the respondent may file his written objection in this case. You have received the copies?
Yes.
One line may be observed, relief, interim relief may be considered on that day.
The prayer for grant of interim relief may be considered on the next date fix, after next date fix, list accordingly.
Obliged.
Why have you objection, my lord?
You have been given opportunity to file written objection.
Yes, my lord.
You file,
But all the order, 3 order they have challenged, my lord. All the order.
you take any objection you want to take in your written objection, take any ground, we'll consider.
Obliged.
Subsequent bail application lodged. LCR may be
Hmm.
called for lodged.
Bail or anticipatory bail?
Anticipatory bail lodged. Pre-arrest bail application.
What is the stage?
What's your appearance stage lodged?
You appear before the trial court.
The difficulty is that offense is tribal by sessions lodged.
What is the offense?
The allegation of rape is there lodged.
What is your ground?
So earlier
You
bail
have been shown as an absconder.
absconder lodged. I have not been searched lodged. And I have been shown as an absconder in the search sheet lodged.
No, what is your ground for this bail? What is your case?
So earlier lordship, if lordship comes to page 35 lordship, earlier bail applications are rejected lordship. Regarding the custodial interrogation, lordship has made observation lordship. Now only ground I have taken is medical issues lordship.
What medical issues?
He has been suffering from trauma and lordship, high blood pressures lordship. And under such circumstances, if he is put behind the bar lordship, then his health may be jeopardized lordship.
High blood pressure is
High BP and
high BPN,
that is the problem he has been.
only high
facing,
BP.
yes.
You will be given medicine in jail if you are arrested.
Lordship, custodial interrogation in this case, if
You pray before the trial court.
the committal court has no power to grant bail lordship. Only difficulty is that lordship.
What are the new grounds after the rejection of the bail order?
So I have only taken the medical ground lordship.
Yes, Mr.
The materials are there, lordship. If I look into the.
Then if materials are there, we are rejecting this bail application. Heard Mr. D. Medhi, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor. This anticipatory bail application has been filed by the petitioner, namely Muhammad Safiqul Islam, alias Muhammad Safiqul Islam, under Section 482 of BNSS 2023, apprehending his arrest in PRC case number 423/2025, corresponding to Bipuria PS case number 7/2025, under sections 85/79/64/351 within bracket 2/3 within bracket 5 of BNSS. The gist of accusation in this accusation
That I had mentioned on page 3 lordship. Para 3 lordship.
quote para 3, 4, 5 from page 36. Stop. It is pertinent to mention herein that on an earlier occasion also, the petitioner had approached this court by filing an application for anticipatory bail. However, on that occasion, after perusal of the materials on record, the prayer for bail was rejected by this court by its order dated 7/5/2026, passed in AB case number 594/2026. Learned counsel for the petitioner has submitted that this time the petitioner has approached this court on mainly on medical grounds. That is the where is the statement?
Lordship, on para on page 6, Lordship, para 8.
Mainly on medical ground. That is, he is suffering from stress, depression, anxiety, and frequent chest pain. Where are the documents?
So one annex of 4, Lordship,
Page number?
page number 30, Lordship. Is under medication.
In support of his submission, the learned counsel for the petitioner has produced an advice slip issued by Naubosia Block PHC on 18/6/2026, indicating therein that the petitioner suffered from severe chest pain and cough and difficulty in respiration and was prescribed certain medicines.
It was also referred to higher medical.
It also appears that the petitioner was also referred to what is this LR? What is this referred to?
Lakhimpur Medical College and Hospital.
Referred to Lakhimpur Medical College and Hospital for better treatment. Stop. On the other hand, learned additional public prosecutor has submitted that there are sufficient incriminating materials against the petitioner on record. And after considering all the materials, this court had rejected his earlier bail application. He submits that no new ground for seeking bail has been made out by the present petitioner. Stop. I have considered the submissions made by the learned counsel for the both sides and have gone through the records. It appears that the medical certificate, the advice slip issued by the Naobusia PHC is of 18/6/2026, and after that date, almost 2 months have lapsed, and no up-to-date status of the health condition of the petitioner is available before this court. Otherwise, also on perusal of the said document, the ailment with which the petitioner is suffering does not appear to be very serious. On the other hand, the petitioner has been charge sheeted for committing heinous offense like rape on his own daughter-in-law, and the previous order of this court indicates that the daughter-in-law in her statement recorded under section 183 of BNSS have categorically implicated the present petitioner of having committed the alleged offense. Under such circumstances, this court is not inclined to.
Please, Your Lordship, one more submission, Lordship. Thus, that may be included, Lordship. No medical examination was also done, Lordship, in this case, Lordship,
Medical examination
of the victim, Lordship. On page 22, that will be clear, Lordship. And also, Lordship, after submission of the medical report, we have filed the instant petition on 26/6. The report.
petitioner Kyosumi. Learned counsel for the petitioner also submits that the victim was not medically examined, and as such, there is no medical report regarding indicating commission of the offense alleged against the petitioner. Last para kya tha? This court is not inclined to grant a favorable order under section 482 of BNSS in favor of the present petitioner. This anticipatory bail application is accordingly dismissed.
Lordship, observation may be made upon his appearance. Honorable court below may consider the application as per law, Lordship.
That court will otherwise also do. Why observation is required?
Deeply.
May please, Your Lordship. Lordship, we have filed this IA for correction in order dated 7/7 of 26, Lordship. There in point number 2, Lordship, the sections are not correctly put, Lordship. The correct sections we have mentioned in page number 4, Lordship, from 5th line, Lordship.
What correction you are seeking?
We are seeking 120B 406-379, 420 of the IPC read with section 13(1) of the ACP Act, Lordship. But in point number 2, it's not there.
What point number 2?
Point number 2 of the order, Lordship.
Para 2 of the order.
Para 4, point number 2 of the main order, Lordship.
Not point. Para.
Para 2.
Para 2 of the
Order dated?
Order dated 7/7.
what is the mistake?
Not mistake, my lord. In the charge sheet, my lord, some more sections were added. That's why when we approached the review order, they said this section, the entry that I have given, my lord, in last page of my application is also fine. What is required, my lord? Page 6, my lord. It requires that section 420 read with 13(1) of the ACP Act it is our mistake. We have not given it, my lord.
Then if you have not given, how can this court?
Yes, now we required it, my lord. Otherwise, they say there is the other section you have not given. That's why we pray that it may be incorporated. Other sections are there, or X 120B.
No, but how it will help you? You were directed to pray.
When? I said you, why you have suppressed these two sections? It is my mistake, that's why I have come.
No, but the direction was
To
to
appear.
appear and file a fresh bail application.
Yes, but I prayed for time also, when there is this mistake was found, they detected, I prayed for time, they have given the time minute. I'll go.
I don't know how it matters, because your prayer was
Directed to appear and pray for
fresh bail.
fresh bail.
In your fresh bail application, you can mention all the sections. The court below would be considering your fresh bail application, not.
Well, in that even your lordship may dispose it to that direction. Petitioner will file fresh application adding this new added section.
Heard Mr. S.C. Bishwas, the learned counsel for the petitioner. This interlocutory application has been filed by the petitioner Ajay Pal in connection with anticipatory bail application number 1493/2026, seeking correction of modification of the order in as much as it is submitted by the learned counsel for the petitioner that some sections involved in the case pending before the Court of Learned Chief Judicial Magistrate South Salmara were inadvertently not mentioned in the anticipatory bail application, and consequently same were not reflected in the order dated 7/7/2026, passed in AB case number 1493/2026. So it appears learned counsel for the petitioner submits that though section 120B, 120 capital B /406/379 of Indian Penal Code were mentioned in the paragraph number 2 of the aforementioned order. However, section, what is not mentioned?
420 and 420 and
Which one? Which one?
13 within bracket 1 of ACP Act.
What is ACP Act? Assam Cattle Preservation Act. However, section 420 of the Indian Penal Code, as well as section 13 within bracket 1 of the Assam Cattle Preservation Act, was not mentioned in the said order. Hence, he prays for rectifying the said order accordingly. Stop. On perusal of the order dated
7/7.
7/7/2026, passed in AB case number 191493/2026. It appears that the anticipatory bail application filed by the present petitioner was disposed of with an observation that petitioner may move an application for bail before the trial court on the
31/7/26.
on the next date fixed. And on his appearance, the trial court shall consider the application as per law. In view of the directions given by this court in para number 6 of the order dated 7/7/2026 in AB case number 1493/2026, even if there is some error in omitting error in not mentioning some of the sections in paragraph number 2 of the said order, this court is of considered opinion that no further rectification or modification is required, as no relief was granted by the said order to the petitioner. Rather, the petitioner was given a liberty to approach the trial court by filing an appropriate bail application. If the petitioner chooses to file an bail application before the trial court, he may mention relevant provisions of law in the said bail applications. This interlocutory application is accordingly disposed of.
My lord, I may given little time because earlier time was already expired. 15 days time may be given. I am from Manka chairman.
Since the time granted for moving a bail application to the petitioner in the aforesaid order was on 31/7/2026, and since that date has lapsed, when is the next date fixed?
Give me 15 days time will appear.
15 days more is granted to the petitioner to move a fresh bail application before the trial court. This bail application is accordingly disposed.
Lordship, service complete, Lordship, the name of the respondent reflected in the Lordship cause list. It may be fixed for hearing.
The records of the trial court heard Mr. L.R. Majumdar, the learned counsel for the appellant. It appears from record that service of notice on all the respondents is complete in this case. It also appears that the trial court records have been received. Hence, this matter is ready for hearing. Please this appeal for hearing after 4 weeks on a date to be fixed by this.
All right.
Item 18 and 19.
May I please, Your Lordship? Your Lordship, kindly the matter may be fixed for admission hearing, Lordship.
What happened in mediation?
Mediation failed, Lordship.
Heard Ms. B. Hajorika, the learned counsel for the appellant. Also heard Mr. A.J. Ghosh, the learned counsel appearing for respondent. It is submitted and that though this matter was referred to mediation, however, the effort for arriving at an amicable settlement has failed, and the mediator has submitted a failure report. In view of above, let this matter be listed for record, I say, listed for hearing. What is the matter?
Modification of the pilot for modify
10-8,
2026.
25.
26.
And in my case, however, he is already, that respondent is already represented.
Who is for?
4 is the owner of the
Who is appearing for?
SM Mullah.
You can appear in this case also, you can accept notice. Same respondent. You take instruction.
Yes.
Heard.
Same. And Lordship,
Wait,
the
wait.
50% was directed to be deposited.
Where it is in the stage in the we have
There was an IA, that IA for stay. While allowing this IA, that IA, payment.
No, we'll take up I later on. Common order in 627 and 224. 627 and in item number 20 and 21. Common order. Huh?
এটা ভুল হয়েছিল।
Heard, Mr. What is your name? G.J. Sharma. What is your name?
GJ Sharma Lordship.
Heard, Mr. G.J. Sharma, learned counsel for the appellants in MAC appeal number 627/2024, as well as Mr. A. Bhattacharya, the learned counsel for the respondent insurance company. Respondent number. You are appearing for respondent number? Respondent number 1. Insurance companies, comma, Miss P. Borthakur appearing for respondent number 3 or is also in insurance company.
Number 21, I am for respondent number 5.
3 has become 5. Similarly, Lordship,
Respondent number,
In
Six
21,
of them.
I am for respondent number 3 and
respondent number 3, and Mr. J. Mullah, sorry, SM Mullah appearing for respondent number 2 in MAC appeal number 627/2024.
Lordship, there is one small mistake, Lordship. May I place it? In my case, respondent number 4 is respondent number 6 in their case, Lordship, because there are 3 claimants. So respondent number 1, 2, 3 are the claimants, then followed by the other respondents.
Who is 6?
6 in my case, it is duly served. 6 which is 4 in my case, that is duly served by order dated 22/5/26. If your Lordship peruses that order 22/5/26. 22/5/26.
It appears from record that in the MAC appeal number 627/2024, the notice issued to all respondents have been duly served. However, in MAC appeal number 627, MAC appeal number 328/2026, the notice upon respondent number 5,
Not, that is actually 6, Lordship.
in my appeal, it is respondent number 4, notice issued on 10/8.
respondent number 4. Let me see. Malikon Khanum,
Malika.
you are appearing for.
Yes, sir.
Respondent number 4 is yet to serve, yet to be served. However, as Mr. S.M. Mullah is appearing for Malikon Khanum in MAC Appeal number 627/2024, he is requested to take necessary instruction from the said respondent as to whether he may also appear in MAC Appeal number 328/2026. He shall inform this court about the same on the next date fixed next week. Let this matter be listed on 28th of August.
Obliged.
Obliged.
Please, Your Lordship. Lordship, the matter was supposed to be listed in the hearing column, and the
Hearing.
service is complete.
Heard Mr. R. Sharma.
Yes, Sharma.
Heard Mr. S. Sharma, learned counsel for the appellant. Also heard Mr. S. I. Akan, learned counsel for respondent number 1, 2, and 3. This appeal is ready for hearing. Hence, list it for hearing after 4 weeks on a date. After 4 weeks on a date to be fixed by registry.
Good.
May it please your lordship. Your lordship, in this case, there was a direction for taking steps through dusty service upon the respondents, your lordship. Accordingly, steps were taken, your lordship, and we have filed an affidavit, your lordship. But that is not on record, your lordship.
Heard Ms. P. Berthakur, the learned counsel for the applicant, who submits that in pursuant to the directions of this court, the applicant had taken steps for issuance of notice upon the respondent by dusty mode, and accordingly has also filed an affidavit in compliance thereto. However, said affidavit is not there in record. Stop. She submits that the registry may be directed to place the affidavit along with the record on the next date fix. Stop. The registry shall tag the affidavit in compliance filed by the present applicant regarding dusty service along with this record on the next date fix. Lays this matter on 14th September.
Obliged.
May I please, Your Lordship? Lordship, service is complete in terms, I think.
Lordship, I am appearing for respondent number 1.
Heard Mr. What is your name?
A Brahmo.
A.
Brahmo, Lordship.
A. Brahma, learned counsel for a appellant. Also heard Miss P. Bothakur appearing for respondent number 1, as well as Miss, what is her name?
Ma'am.
What is your name?
B. Burman.
B.
B. Burman.
B. Burman, learned counsel appearing for respondent number 2, who submits that she has been instructed by the respondent number 2 to appear in this case, and she would be filing her wakalatnama shortly. Hence, prays for some more time.
3, no? 2 and 3.
2 and 3. 2 and 3. The prayer is allowed. Let this matter be not hearing. We can fix it for hearing. Or you file wakalatnama. Let this matter be listed again on 14th of September. Let them file wakalatnama.
Lordship, item 25, same Lordship. Analogous matter, Lordship.
25, same order.
I am appearing for respondent number 1.
Same order.
Obliged.
Must oblige.
My lord, the respondents have appeared in this case, my lord. It's a matrimonial dispute, my lord. Let the matter may go up for mediation, my lord.
Yes, I do agree. Yes,
There.
ma'am.
Heard Mr. A. Tiwari, the learned counsel for the appellant. Also heard Mr. P. K. Deka,
I am for respondent 1, my lord.
the learned counsel for respondent number 1, as well as Mr. R. Ghosh appearing for respondent number 2. Who is R2? Huh? Why he has been made party?
Yes. My lord, in the trial court, he was made party, my lord. That is why I need to, because he was proceeded ex parte, my lord. So my lord,
But
once his
what
name,
re- what
respondent number
relief-
2 was there, my lord, in the, so my lord, I had to make my lord. Even it was there in the-
What relief you are seeking against? No relief.
Now, as of now, my lord, nothing is
Okay.
received.
This, it is submitted at bar that there is a possibility of amicable settlement. There is an element of settlement in this case. Hence, it is prayed that the matter may be referred to mediation. The prayer is allowed. Let this matter be sent for mediation. The parties shall appear before the appointed mediator on the date to be fixed by the Gauhati High Court Mediation Center. The report of mediation may be submitted before this court. There must, after Puja vacation,
Okay. Well, before Puja vacation. my lord.
before Puja vacation.
Well, report be after Puja vacation, my lord. Report be after Puja vacation, my lord.
After 2nd November. This case will be listed on 2nd November.
Yes, my lord.
Before that
Before
mediation
that,
process.
we'll try to settle the matter. I'm deeply obliged, lord.
In this case, my lord, earlier, my lord, usual course, my lord, notice was, steps was taken on 6/8, my lord. And yesterday was taken, my lord, by sweet post, my lord.
So we'll await sweet post.
My lord.
Heard Mr. A. Rahman, learned counsel.
My lord, ASOP on behalf of A. Roman.
Heard Mr. S.
ASOP.
Hawk, learned counsel for the appellant, who submits that though the office note dated 17/8/2026 shows that no steps for issuance of notice has been taken by the appellant. However, he submits that it is only yesterday
Yes.
that the appellant has taken steps for issuance of notice upon the respondents by speed post.
My
Therefore, he prays for await the service report. The prayer is allowed. Let this matter be listed after 4 weeks on a date to be fixed by registry.
my
May I please, Fellowship? We are the newly engaged counsel. We're gonna file the wakalat number 2.
For the petitioners,
Yes, Lord.
what is your name?
P. Lamu, Lordship.
P.
P. Lamu.
Heard Miss P. Lamu, learned counsel for the petitioner. Also heard Mr. G. Rahu, learned counsel for the contemner. It is submitted by the counsel for the petitioner that she has been newly engaged by the petitioner in this case, and she would be filing her wakalatnama shortly. Hence, she prays. Earlier you were appearing for the petitioner. Hence, she prays for some more time for filing wakalatnama. Also on Mr. S. Islam, who submits that he was earlier engaged counsel for the petitioner. However, since the petitioner has decided to engage a new set of counsel, his name may not be reflected in the cause list henceforth. The prayer is allowed. Registry is directed not to reflect the name of Mr. S. Islam in the cause list henceforth. List
Can-
this matter.
Can the matter be fixed, Lordship? At 2 September, after 2 weeks.
Let this matter be listed again on 2nd of September.
If you-
29 to 36.
May please your lordship, my lord, I have just now been informed that in item number 30, the respondent number 1 has passed away.
We have furnished the details of the legal.
And
heirs
in
also.
fact, it has abated also.
No, it's, we will not object. We'll furnish it. It may be recorded, we have informed today, lordship.
They have informed us today, my lord. Will, because in the meantime, it has abated from the next of kin certificate.
Yes, yes.
That he has passed away on 30th of April. Item number 30, my lord.
Item number 30 লিখিব. These are delay condonation
These are
applications.
delay condonation applications.
All connected. Yes.
Item number 30 লিখিব. Heard Mr. A.
And
Decker,
Deca.
N. Decker, the learned counsel for the respondent. Learned counsel for the
Copy number 1.
N. Decker is for the
Appellant, applicant.
applicant.
Applicants.
Applicant. Also Mr.
SD Purkas.
S.D. Purkasta, appearing for opposite party number 1, who submits that the opposite party number 1 has expired on
34, 2026.
34,
30th April, 2026.
2026. The learned counsel for the applicant has submitted that in view of the fact of demise of opposite party number 1, the applicant may be granted some time to take appropriate steps for for substituting the legal heirs of the deceased opposite party number 1.
We have furnished the details also.
The prayer is allowed. Let this matter be listed when after 4 weeks. After 4 weeks. In other matters,
Let them come together, my lord. There are interim orders, my lord, let them be continued till the next date.
in other matters, 29 to
36.
36. In view of fixing of the IA number
3254.
3254/2024, after 4 weeks, let these matters be also listed along with the said interlocutory application after 4 weeks. The interim relief granted earlier shall continue till next day.
47 and 48.
We see none has appeared for the applicant. The petitioner on call. List this matter after a week on a date to be fixed. Same order.
May I please? Now this is completed, my lord. In this regard, the respondent also appeared.
Heard Mr. S. Sakya,
Ma'am.
learned counsel for the appellant. Also heard Mr. D. Nandi. This is item number
41.
D. Nandi,
Yes.
appearing for the sole respondent.
Yes, for this whole.
Sole respondent. Records this. Whether
I may be permitted to file my objection because they have totally suppressed the facts of what the plaintiff he has given during the cross examination she has admitted. Those facts I want to bring to surface.
whether trial court records will
That petition is present here.
whether trial court records will be necessary.
Yes, Mr. Vida, this is the, my lord, cross their counterclaim was allowed, my lord. Because earlier the agreement, they had violated the agreement. I am the landlord, my lord. But evicted, my lord, they have evicted during the pendency without filing any specific performance suit, my lord. out of 13 lakh rupees, they only pay 2 lakh rupees. my lord.
Let the trial court record of 405/2014 be called for from the concerned court. The learned counsel for the respondent submits that he may be allowed to file a written objection in this case. The prayer is allowed. The written objection in the interlocutory application.
Yes,
In the connected interlocutory application,
both for the, against the RFA as well as the IA.
as well as in this appeal.
I
The
may be
prayer-
given 4 weeks time.
The prayer is allowed. Let this matter be listed after 4 weeks. Any interim relief,
Yes, my lord.
the interim relief shall continue till next day.
Obliged, my lord.
May I please, Lordship, the affidavit has been filed by the respondent. We would like to file the reply, Lordship. Can the matter be fixed after tomorrow? After tomorrow, Lordship.
Can I take instruction from the secretary?
What instruction?
Regarding this, there.
There is a affidavit they filed, Lordship. We would like to file the reply, Lordship. Simple as that.
Any interim relief is
Yes,
No, sir.
Lordship, yes, there is a
What has happened, your lordship, on the
undertaken taken by
not
the.
in this manner. Let him submit. I'm asked one at a time. If you jump over each other, I will not understand anything. Yes.
Apologise.
What has happened, your lordship? The matter was listed before this ordinary bench of this honorable court, and on the very last hour, the same could not be concluded, and the appellant side were contesting for stay, but we objected to the same because our submissions were not heard because the court was rising at 1 p.m. So they have stated they pressed for stay, but they have given an undertaking said we will not construct till the next day. So there was no stay to that regard. Stay of the it was just an undertaking from us.
Okay, no, they just want to file reply against. Let them file the reply.
They have to promote your lordship.
When
That may be fixed. Is your Lordship, this is.
heard Miss
P. Lamu.
P. Lamu, the learned counsel for the appellant slash applicant, also heard Mr. J. Das, appearing for the sole respondent.
Yes, no, all the respondents.
For all the respondents slash opposite parties. Learned counsel for the appellant slash applicant submits that the appellant slash applicant may be granted some time to file and file a reply against the affidavit in opposition against the written objection filed by the respondent slash opposite party in the connected interlocutory application. The prayer is allowed. Let this matter be listed. 11th of September.
Let the undertaking be continued till the next day. Lordship.
No, your
If the
that was-
construction happen,
as the matter was not heard on our side.
let the
it was
let the
undertaken.
undertaking be continued for the next.
Yes, sir.
I wish for stay your injunction, your lordship.
There is no reflection about any undertaking.
There is a reflection that construction will be not held by them.
Where?
Admittedly, we are in possession, your lordship.
Yeah.
There is a report from the Nazir also that our sewage pipeline were cut off.
We took on the undertaking because
Okay. What about the undertaking?
Yes,
Undertaking, your lordship, only 2 days, your lordship. We will
undertaking.
not do anything, but there may not be a continuation of the undertaking, your lordship.
No,
Only
we
2 days, your lordship, nothing will happen.
will reflect it. You
Yes,
give
Lordship.
assurance to this court. Mr. Das, the learned counsel for the respondents, submitted submits that the undertaking
Lordship, the matter is even in the 11th September. That
we'll
undertaking
fix a short date. We'll fix a shorter date.
day after tomorrow as they date, Your Lordship.
Third September.
It is impossible to prepare, it's a very low.
They have paid for 2
There
days.
no undertaking.
Day after tomorrow, it will be short. Kindly.
Third. Not day after tomorrow, on 3rd of September.
Then it may be not continued, Your Lordship, the undertaking. It's a long time, Your Lordship. We are suffering from-
fixing.
We are in possession of this premises, Schedule C premises. By stating false facts, Your Lordship, false statements, they have taken the stay. And against that, when we appeared and we contested, the stay was vacated.
You maintain this status quo for 1 more week.
Yes.
So, Your Lordship, let my senior come, Your Lordship, then, after some time. Because there are a lot of things that we have.
Okay, let his senior come. ये half लिख के रखना. Mr. Majumdar will be coming.
Yes.
For my senior as Deka will become.
Let him come.
Give blood.
ये अमिता आधे से शुरू करना पड़ेगा. Yes.
Please, Your Lordship. The claimant is the appellant here in Manila. The notices have been served by office note dated 11/8.
Who is appearing for?
Perhaps nobody is appearing, man.
How many respondents are there?
ICICI Lombard.
How many respondents?
1.
2 respondents.
Same. Mane 1 and 2, both I say.
You have not made the owner party.
No, not required because only, my lords, only for enhancement we have come as the liability is on the insurance company. We have made them pro forma. Not
Heard Mr. A.K. Sahewala, the learned counsel for the appellant. Though office note dated 11/8/2026 shows that notices issued to respondent number 1 and 2 have been duly served, however, none has appeared for the respondent. Since the records of the concerned MAC case have been received, this appeal is ready for hearing. Hence, let this appeal be listed for hearing after 4 weeks on a date to be fixed by registrar.
Malad, can a date be fixed, man? Otherwise, this will never come up.
26th November.
26th
November.
November.
Yes.
Malas, in that event, can I pray that at least because we are unable to file the execution application?
Why?
Because the entire record is before your lordship. At least scan copies may be retained or some direction may be given that otherwise the money is stuck, Malad. That is the only issue. We have tried to file the either the
next para. Learned counsel for the appellant has submitted that since the records of MAC case number 1732/2017 have been requisitioned in connection with this appeal, the appellant are unable to file any execution case before the concerned tribunal, and therefore he prays for either sending the records back to the tribunal by keeping a scanned copy thereof in this court, or sending a scanned copy of the records to the concerned tribunal. So, considering the facts, considering the submissions made by the learned counsel for the appellant, the registry is directed to send back a scanned copy of the the records of MSC case number 1732/2017 to the Motor Accident Claims Tribunal number 3, Kamrup Metro, so as to facilitate filing of an execution case by the present appellant / claimant before the said tribunal. Stop. List accordingly.
So very obliged.
Article 44.
Lordship, first in this matter, I am agreeing for respondent number 1, Lordship. Today, Lordship, I have filed our objection, Lordship. Lordship, the stay order is appointing, Lordship, that's why Lordship may fix this matter on next week, Lordship, any day. I have filed an objection today, I have served a copy in back of this.
Heard Mr.
J. Das.
J. Das, the learned counsel for the petitioner. This is item number.
TRP IO 244.
What is your name?
PJ Datta.
Also heard Mr. P.J. Datta, learned counsel for respondent number 1, as well as Mr. S.K. Medhi, learned central government counsel appearing for respondent number 2. Learned counsel for respondent number 1 has submitted that he has filed a written objection again in this CRPIO and prays for listing this matter for hearing shortly. On the other hand, Mr. S.K. Medhi, learned central government counsel, prays for some more time. You will be filing written objection.
Yeah, they are received, raising issue. So that matter will be hard to have some.
I have filed Lordship on maintainability, Lordship.
Okay.
That's why Lordship may fix this matter on next week, any day.
We have not received copy yet, Lordship.
Lordship, I will serve, perhaps clerk has received, Lordship.
Because without having copy, it cannot be filed actually.
The respondent number 1 is directed to furnish a copy of written objection to the learned counsel for the petitioners within 2 days from the date of this order. Let this matter be listed again, 10th of September.
Lordship, kindly prepone this matter, because otherwise the surfacing matter, Lordship, bank could not proceed any due to this day, Lordship.
10th.
27 or 28, Lordship.
27.
We have lot of cases fixed.
Then on 8 of them.
8th of September.
Obliged, Lord. Interim order may extend, Lordship.
The interim order shall continue till next.
Highly obliged, Lordship.
Right, Your Lordship. That as per office note dated 17/8/26, Lordship, respondent number 1 appeared, and 2 regarding 2, Lordship. The unserved notice has been received back, Lordship, with postal remark not found. In this case, Lordship, I may be allowed to take steps to paper publication, Lordship.
Heard Ms. M. Chaudhary, the learned counsel for the appellant. Also heard Mr. B.
J. Talukdar.
B. J. Talukdar, the learned counsel for the respondent number 1. The office note dated 17/8/2026 shows that the notice issued to respondent number 2 has returned back with an endorsement within inverted comma, addressee not found, full stop. The learned counsel for the petition for the appellant has prayed for allowing the appellant to take steps for issuance of notice upon the respondent by substituted mode of publication of the notice in the newspaper. The prayer is allowed. The appellant shall take step within 15 days of the date of this order for publication of the notice in the newspaper, notice issued to the respondent number 2 in a newspaper which is widely circulated in the last known address of the respondent number 2. Let this matter be listed. The date of appearance in the notice should be mentioned as 30 September.
Appearance, Lordship.
Yes, 30 September. Let this matter be listed thereafter.
Must oblige, Lordship.
I am taking a short.
Next Friday.
Friday.
Agree, learned counsel for the respondent, last line, learned counsel for the respondent agrees to abide by the undertaking which he had given before this court on which date? No, 9.
On 12. The appeal order has been.
12/8/2026. Let this matter be listed. When?
Next Friday.
Friday, sir.
Fridays. On 3rd September will be good.
Will be too long, Lordship. They are pressing the injunction.
Okay, on Friday, on
Friday. 28.
28th.
Deeply obliged, Lordship.
May it please your Lordship. This I is for condemnation of delay of 92 days in filing the matrimonial appeal.
Would like to file our objection here, ma'am.
Heard Miss M. Dutta, the learned counsel for the applicant. Also heard Mr. B.J. Talukdar, learned counsel for the respondent, who prays for some time for filing written objection against the prayer for condonation of delay made by the applicant. The prayer is allowed. Let this matter be listed 11th of September.
Obliged.
After third week of September.
No, 11th of September.
Last occasion also they have took time.
Okay. Obliged.
Yeah, please, Your Lordship. My lord, as per office note, OP number 3 address was insufficient. My lord, I want to beg to state that in OP number 3 is the minor child of OP number 1 and respondent number 1 and respondent number 1 and 2 has been represented.
Who is represent? You can represent OP number 3.
I am represented all the claimants.
Okay.
All the claimants. My lord, inadvertently we missed to take steps regarding OP number 4 and 5. Lordship may kindly give us another opportunity to take the steps for 4 and 5. The owner and client.
Your insurance company.
Insurance company.
You are opposing.
Yes, Lordship. 690 days.
Okay. Let them take steps. Heard Mr. C. Fukan, the learned counsel for the applicant. Also heard Mr.
A.T. Shokar.
A.T. Sharkar, appearing for opposite party number 1, 2, and 3. Learned counsel for the applicant has prayed for some more time for taking steps for issuance of notice upon opposite party number 4 and 5. The prayer is allowed. The applicant shall take steps for opposite party for issuance of notice on opposite party number 4 and 5 within 7 days from the date of this order, returnable on 23rd September. List account.
Lordship, OP number 3 need not to be taken any steps.
No, he is representing 1, 2, and 3.
Item 49.
Lordship, as per office note dated 17/8/2026, the service report upon respondent 1 and 2 has been served. It has been received by them, but the respondent 3 and respondent 4, their precise locations could not be found.
So what to do?
We need some time to ascertain the proper address, my lordship.
You are insurance company.
Yes, my lordship, or United India Insurance.
Heard Miss M. Setia, the learned counsel for the applicant. On perusal of the office note dated 17/8/2026, it appears that notice issued to the opposite party number 1 and 2 have been duly served, whereas the addresses of this opposite party number 3 and 4 could not be located by the processor. The applicant is allowed some time now. You have to take steps by speed post also.
Yes, my lordship.
Allowed some time to find out proper address of the opposite party number 3 and 4. The applicant shall also take fresh steps for issuance of notice upon opposite party number 4 and 5, 3 and 4 by speed post, as well as by usual mode, after ascertaining proper address within 15 days of the date of this order, returnable on 30th of September. List accordingly.
Here also, my lordship, as per office note dated 17/8/2026, notice service report of respondent 1 and 4 has been served and it has been received by them. My lordship, respondent 3, respondent 5 and respondent 6, their addresses also could not be found.
Heard Miss M. Setia, the learned counsel for the applicant. You are appearing for? Also heard Miss R. Datta, appearing for opposite party number 3, 2. It appears that the notice is sent to opposite party number 3, 5 and 6 have returned with postal endorsement within inverted comma, incomplete address, inverted comma close. Whereas notice issued to respondent number 1, 4 and 1 and 4 have returned after due service. In respect of opposite party number 5, it has been reported that the opposite party number 5 have expired. As such, stop. In view of above, the applicant is directed to take fresh steps for issuance of notice upon opposite party number 3, 5 and 6 after ascertaining proper address by speed post as well as by usual mode within 15 days from the date of this order, returnable on 30th of September. The applicant may also take appropriate steps with regard in respect of the deceased opposite party number 5 before the next date fixed. List accordingly.
Right resolution. The delay of my lord 3 days.
Opposing.
3 days.
Heard Mr. T. Kolita, the learned counsel for the applicant. Also admits, what is your name?
For the respondent number 1, today I'm filing the wakalat.
What is your name?
AG Chaudhary.
A.G. Chaudhary.
Lordship, may kindly see office note 17/8/26 for respondent number 2. Well, he passed away, my lord. Respondent number 2.
Then
The problem is that, my lord, the respondent number 2 happens to be the husband of respondent number 1.
Oh.
Respondent number 1 is the claimant number. So technically, she becomes the owner of the property.
and one is the owner of the offending vehicle.
2 was the owner of the vehicle.
Okay.
Son died while riding the vehicle belonging to his father.
Then one does not have any other legal heir.
No,
2 does not have any other legal heir.
no, my lord, because on record, my lord, because she was the sole claimant.
Okay. But she is before us in this appeal in a different capacity.
Yes, my lord.
क्या लिखा? And counsel for opposite party number 1 has submitted that she would be filing her wakalatnama in this case shortly. It also appears from the office note dated 17/8/2026 that opposite party number 2 has expired on 15/7/2023, and as the opposite party number 1 15/7/2023 stop. The learned counsel for the applicant has submitted that since the opposite party number 1, who is the wife of the deceased respondent number 2, is already on record, there is no necessity of substituting any legal heir of the deceased opposite party number 2. Stop. We can dispose of this I if you are not opposing. But you file your wakalatnama.
Filing today, Your Lordship.
This interlocutory application has been filed by the applicant insurance company under section 5 of the Limitation Act 1963, praying for condonation of the delay of 3 days in filing the connected MAC appeal, wherein the judgment and order dated 17/1/2026 passed by the Motor Accident Claims Tribunal, Sibsagar, in MSC case number 11/2020 has been impugned. Stop. The learned counsel for the opposite party number 1, considering the short period of delay of only 3 days, does not raise any objection. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the grounds stated in the instant interlocutory application for delay in preferring the connected appeal beyond the period of limitation. Stop. Considering the fact that the delay is only of 3 days, as well as considering the grounds stated in the interlocutory application to be sufficient cause which prevented the present applicant in preferring the connected appeal within the prescribed period of limitation, the delay of 3 days in preferring the connected appeal is hereby condoned and this interlocutory application is allowed. Stop. The registry shall register the connected MAC appeal and list the same for admission after a week on a date to be fixed by it.
File your
Lordship, I am appealing for respondent. I may be allowed 3 weeks time to file my affidavit in opposition.
What is your name?
PR Chaudhary on behalf of H. Gupta.
Heard Mr. P.R. Chaudhary. Heard Mr. H. Gupta, the learned counsel for the applicants. Also heard Mr. A. Sahad, appearing for whom, which respondent?
Sole respondent, there is only
Appearing
one.
for the sole respondent, who prays for some time for filing a written objection against the prayer for condonation of delay made by the present applicant. The prayer is allowed. Let this matter be listed 18th of September.
Lord, and execution is also going on, my lord. Can it be on 28th, my lord, if my learned find?
No, Lordship, it is not possible for him. He is hailing from Dibrugarh. And in view of present flag situation, it is not possible on his part. There is
Because
no
they are
regular
insisting on
marker which
execution,
would
Lord.
be
They have filed execution. And only 67 days delay. my
can
lord.
be restored under section 144.
Only 67 days delay, my lord. My learned friend.
Yeah, commanded this. All of commanded. 8th of September.
8 September.
8th September.
I don't-
Get the objection of the defense, sir. Please. My lord, there is delay of more than 150 days. my lord. And we'd like to file an objection. We've entered appearance.
Heard Mr. R. Borpujari, learned standing counsel, Revenue Department, appearing for the applicant. Also heard Mr. K. N. Chaudhary, the learned senior counsel, assisted by Mr. R. J. Das, learned counsel for sole respondent,
No, my lord, there is
number 1.
opposite party number 1, my lord.
learned counsel for opposite party number 1.
Others are, my lord, 2, 3, and 4 are pro forma opposite party. We have already taken steps. my lord.
None has appeared for the other opposite parties. Learned senior counsel for the opposite party number 1 has prayed for some time for filing a written objection against the prayer for condonation of delay made by the applicant. Stop the prayer is allowed. Let this matter be listed when?
After 3 weeks, my lord.
18th September.
I'm sorry.
Item 54.
May I please say, Lordship? Lordship, in this case, on behalf of the petitioner, we have taken steps, but as per service note, service report has been awaited.
You have taken steps by speed post also.
Lordship, okay. We have taken steps
By usual mode. You take steps by speed post also.
with post, registered post. But service report has been awaited as per office note, Lordship.
Heard Miss, what is your name?
Zedeka.
J. Deka, the learned counsel for the applicant. On perusal of the office note dated 70. Seventeen 8/2026, it appears that the service report in respect of notice issued to sole respondent is awaited. Stop. The registry is directed to place the postal track consignment report of notices issued to respondent by speed post before this court on the next date fixed. Let this matter be listed 9th of September.
Thank
Item 55.
May I please, your lordship? Well, I filed this mistake for allowing me the claimant for 50% of the awarded amount, lordship.
Stay has been granted.
Yes, lordship. The order dated
Any objection?
11/11/2024, Your Lordship.
Regarding my lord, withdrawal, my lord, case relates to family pension matter. So they are getting the amount in full salary, my lord. So in that case, my lord, there is no question of loss of dependency, financial loss of dependency. So my prayer, my lord, in regard to withdrawal, my lord, conventional heads, my lord, can be allowed to be withdrawn.
How much it comes?
As per the judgment, my lord,
Make appeal.
if lordship is considering the future prospect also, then it comes about 270,908, including conventional, my lord. Along with the interest, it can be released, my lord.
No, what is your submission? How much may be released?
My lord, I have calculated the amount, my lord. It would be 2,70,908. Future prospect is 15%.
And what is the status in? Who is the claimant?
Your Lordship,
Widow.
wife, son and daughter.
Are you getting the
No, my lord,
salary?
with all respect, my lord, I made a statement that they are not getting the pension from the Assam government. And another statement I have written in my miscase, my lord, for the higher studies of the claimant's son and
Now, why you are not getting the pension?
they have not received the amount. So as per the statement of the claimant, I have stated in my miscase, Your Lordship. Some cases, some of the cases, government not providing the employers, there the internal matter. I do not know about that matter also. In this case,
Lordship, may kindly see page number 18 of the memo, my lord. Judgment, my lord. The official witnesses affirmed. Page number 18, my lord. Para 17. The official witness examined by them, my lord.
Yes.
Family members of the deceased are entitled to receive the basic pay of the deceased until his retirement. And he has mentioned that according to the Assam government's compulsory family pension scheme 2017, the family members.
my lord, in paragraph 17, however, he has not admitted that he cannot confirm whether the family member of the deceased are currently receiving the pension under the above scheme. Nothing that the AGA office would know the details of the such pension being received by the family members or not.
My lord, as per the Substitution judgment, my lord, the terms have been used, my lord, received and receivable. Maybe they have not received as of now, but it is receivable to them, my lord. This term has been used in the judgment of Substitution, my lord. Received and receivable.
Okay. Then we will not go into disputed questions in this interlocutory application. In this interlocutory application, you take the amount granted against conventional heads. And regarding other contentions, we'll consider in the appeal.
My lord.
You are not opposed to release of amount granted against conventional heads.
Yeah, no. It can, as well as the future prospect also, I'm ready to, I'm not opposing, my lord. Future prospect and the amount quantified towards conventional heads, my lord.
Heard Mr. N. Devnath. the learned counsel for the applicant, author Mr. T. Kolita, the learned counsel for the opposite party insurance company. This interlocutory application has been filed by the applicant for directing the registry to release the 50% of the awarded amount, which was deposited by the opposite party insurance company before the registry of this court in pursuant to the directions given by this court by its order dated 11/11/2024, passed in IA Civil number 3406/2024. Stop. Learned counsel for the insurance company opposite party has submitted that since the appeal is mainly preferred by the present opposite party on the ground that as per the government's scheme of compassionate pension, where the dependent would continue to get salary equivalent to what the deceased was getting till the date of his retirement. Hence, at this stage, he submits that the insurance company is not opposed to the releasing of, not opposed to disbursing of amount which was granted to the claimants against conventional heads as well as against future prospects, which he submits that comes to rupees 2,70,908. On the other hand, learned counsel for the applicant has submitted that though as per government scheme, the claimant number 1 is entitled to get same amount of money in family pension which the deceased was getting as his salary on the date of his death till the date of his retirement. However, currently they have not yet received any such pension. He further submits that the claimant has also to incur expenditure on the studies of her
Son and
daughter, and as such prays for releasing the entire 50% of the awarded amount which has been deposited by the insurance company. Stop. I have considered the submissions made by learned counsel for both sides. Since one of the contention of the appellant / insurance company in the connected appeal is that according to Assam government's compassionate family pension scheme of 2017, the family members of deceased are entitled to receive the basic pay of the deceased till his date of retirement. And said question is to be, and as such, the said issue, and as such, there is no loss of dependency as calculated by the Motor Accident Claims Tribunal in the impugned judgment. He further submits that since the said issue is one of the main issues to be decided in the connected appeal, and since the insurance company has already deposited 50% of the awarded amount, this court is of considered opinion that out of the deposited money, the undisputed amount of 2,70,908 may be disbursed to the claimant by the registry after proper verification. As such, the registry is directed to disburse an amount of rupees 2,70,908 to the claimants after proper verification. This interlocutory application is accordingly disposed of. In appeal, heard Mr. T. Kolita, the learned counsel for the appellant. Also heard Mr. N. Devnath, the learned counsel for respondent number 1, 2, and 3. The office note dated only 3. Office note dated 14/8/2026 shows that the notice issued to respondent number 4 and 5 have been duly served. Record aise duly served. However, the records of MAC case number 1220/2019 have not yet been received. Hence, registry is directed to issue reminder for the aforesaid records. Let this matter be listed again on 23rd September.
Can it be on 18 or after 2030?
18th September.
The interest may be also released along with the amount till today.
My lord, may I one thing, Lordship, with due permission, my lord. Learned appellant advocate submitted that he has no objection regarding the future prospect, Lordship. If the future prospect plus 272 release with interest, a lump sum amount may be 11 lakhs. As on I told, that must maybe help to the claimant, Lordship. If I lose the appeal, I will furnish the indemnity bond. If I lose, then I will return. And that must maybe help the claimant number 2 and 3 for higher studies, Lordship. That is my humble prayer before Lordship. At least 11 lakhs may be released, Lordship. 50% is more than 26 lakhs, Lordship.
How much was added towards future prospect?
Actual calculation was 4,56,974.
My lord, may kindly see page number 31. Page number 31, para 57 box, my lord. There is an enhancement of 15%, my lord.
Page number 31.
31. Memo paper, my lord.
Yes.
There is an addition of 89,408.
You have added this amount.
Yes, towards future prospect.
In this 2,17,000, this 89 is added.
Then Lordship may kindly see page number 33. The amount quantified towards conventional heads, my lord. Page number 33 and 34.
Eighteen 48. $96. $181. This with this 181, you have added 89.
Amount derived towards future prospect. Plus.
Okay, then it is right. 2 lakhs.
May I pray, Lordship? 89,408 is a future prospect regarding the 15% of the whole salary, my lord. If we calculate 89,400 into 11, 11 is the multiple, my lord. It comes, my lord, 8,94,800. 8. Then conventional head is, your lordship, 1,81,500. That is the actual calculation, lordship. Thereafter interest. His salary was, lordship, 5,96,053
Annual
per
salary.
annum.
What was the multiplier?
Lordship, 11
Fifty.
multiple.
Multiplier is 11.
32 page number, lordship, multiple is 11.
Why this one? Okay.
Multiple because lordship 51 to 55 age. That's why multiple was 11 and future prospect was 15%. Whole salary was 5,96,000.
Out of this 50,26,000,
Yes, lordship.
what was the amount of future prospects?
Future prospect, lordship, 89,408 into 11, it comes 8,94,008. Lordship, I just.
And from that amount, 1/3 deduction has to be made.
If Lordship, the amount of 89,000 is taken as the annual income, my lord, then again, my lord, the multiplier and deduction will come.
Yes. But you are not opposing to payment of release of future amount regarding future.
Yes,
You
I'm not opposing.
you make proper calculation
Lovely.
in a sheet of paper.
Oblige,
Yes,
lordship.
sir, that can be done.
Yeah, I'll rectify the order accordingly.
Highly oblige, lordship. Highly oblige.
If I am convinced with your calculation.
Yes. Highly oblige.
Show it to Mr. Kolita also.
Yes, yes.
Itu correction করিব লাগে।
Delay, my lord, notice may be issued, my lord.
Heard Mr. T. Kolita, the learned counsel for the applicant. This interlocutory application has been filed by the applicant insurance company for condoning the delay of 135 days in preferring the connected MAC appeal. Stop. Let the notices be issued to the opposite parties. The applicant shall take steps for issuance of notice to the opposite parties by speed post as well as by usual mode within 7 days from the date of this order, returnable on 25th September.
Item 57.
Wait, dear Lord. My lord, there is a delay of 43 days in preferring to review petition, that's it.
Heard Miss M. Chaudhary, the learned counsel for the applicant. Also heard Miss R. Chaudhary, the learned
Preparing for respondent number one, they may pray for striking out the name of respondent number two, otherwise your lordship has to issue notice to.
respondent number, Miss R. Chaudhary, assisted by Miss P. Barwa, the learned counsel for opposite party number one. Learned, who is number two?
Two is the owner come driver, lordship. It's not required, lordship.
Learned counsel for the applicant submits that since the opposite party number two is the driver, owner come driver of the offending vehicle, and since the claimant has already been represented in this interlocutory application, the presence of opposite party number two may not be required in this interlocutory application. Hence, she prays for striking out the name of the opposite party number two. Prayer is allowed. This interlocutory application has been filed by the applicant insurance company under Section 5 of the Limitation Act, praying for condonation of delay of 43 days in preferring the review petition, wherein the review of judgment dated 25/5/2026 passed by this court in MSC Appeal number 949/28 2018 has been prayed for. Learned counsel for the applicant submits that the grounds for delay has been stated in paragraph number 3 of the instant interlocutory application. Stop. The learned senior counsel for the opposite party number one has submitted that she does not have any objection considering the grounds stated in the interlocutory application against the prayer for condonation of delay. Stop. Next paragraph. I have considered the submissions made by learned counsel for both sides and have gone through the grounds stated in the instant interlocutory application. Stop. The grounds stated in the instant interlocutory application may be regarded as sufficient cause which prevented the present applicant in preferring the connected review application within the prescribed period of limitation, as such, the delay of 43 days in preferring the connected review application is hereby condoned and this interlocutory application is allowed. Registry is directed to list the connected review application, register the connected review application and list the same in
Pray for fixed date, lordship, because this is not showing our name.
orders column.
Yes, lordship.
In orders column on 2nd of September.
2nd September, lordship.
Wednesday, lordship.
That's
Thursday.
No, can it
Or
be on?
lordship, this Thursday, 27th, if possible.
No, 4th of September. 4th September. Oh, sorry.
3rd September.
If this code is available.
3rd September.
Yes, Lord.
On 3rd September, the name of Miss R. Chaudhary and Miss P. Barwa may be reflected in the cause list as engaged counsel for respondent respondent number one henceforth.
Eighth September.
8th of September.
Eighth. Yes, Lordship. Obliged.
Most obliged, Lordship.
Mid-legal lordship. I have filed this condonation delay petition as a matter of abundant caution only, lordship, because some objection has been raised. The gist of the matter is that I have filed, my claim petition was dismissed for no claim. Within 30 days, we have filed a petition for review before the member tribunal, Dhubri, and that got dismissed on 1/6. Within 60 days, I have filed this appeal, lordship, but some objections have been raised regarding that delay has to be condoned from the date of
Original
dismissal
order.
of the original order.
Original.
The period taken in the review petition before the member tribunal, that has not been considered here. As a matter of abundant caution, I have filed this review. So this may be taken up for disposal, lordship. I have make a statement also.
No, we will issue notice to the other side.
Because it is a matter of 14, section 14, review time taken in the review petition, lordship. I have
No,
made a statement, specific statement, lordship, in para 6 and 7 of my petition, lordship. Because the time taken in review, I am entitled for that part, lordship. So practically there was no delay.
when was the date of?
Lordship, original judgment was given on 28/5/25. Immediately I filed the review within 30 days and review was dismissed on 5/6/26 at page 17, lordship.
Putul, limitation exam. Heard Mr. S.K. Poddar, the learned counsel for the applicant. This interlocutory application has been filed by the applicant, praying for condonation of delay of. No, let us issue notice. It is, let the other, you may have a strong case,
Lordship.
but let the insurance company come, because ultimately this is the
Because it is a-
delay condonation application.
Delay condonation, which according to my humble opinion, lordship, is not required at all, lordship, because I have genuinely pursued the review petition, lordship.
Yes.
And at page 17,
You
lordship,
may get benefit of section 14 of the Limitation Act,
lordship.
but the other side may have some objection if they appear. Let us give a chance.
Lordship.
क्या लिखा? Delay of 338 days in filing the appeal against the judgment and order dated 28/5/2025 passed by the Motor Accident Claims Tribunal Dhubri in MAC case number 151/2015, whereby the claim of the present petitioner was present applicant was dismissed as no claim. Learned, stop, next para. The learned counsel for the applicant has submitted that immediately after passing of the impugned judgment, within 30 days, the applicant had preferred a review application before the Motor Accident Claims Tribunal against the impugned judgment. The said review application was registered as Miss case number
1/25.
1/2025. Stop. He submits that the disposal of the review application took considerable time and it was ultimately disposed of on 5/6/2026. And thereafter, within 90 days thereof, the petitioner has preferred this instant appeal. Stop. He submits that the time consumed in pursuing the review application before the Motor Accident Claims Tribunal by the present applicant may be excluded from the period may be excluded while computing the period of limitation in this appeal in person to as per the provisions contained under Section 14 of the Limitation Act 1963. And as such, there is no delay. And as such, he submits that there is no delay in this instant. Now, as such, the delay of 338 days may be condoned. Stop. The submissions made by learned counsel for the applicant appears to be forceful and reasonable. However, since this is an interlocutory application pertaining to under Section 5 of the Limitation Act pertaining to condonation of delay, this court is of considered opinion that the opposite parties are entitled to get notice of the same. Hence, let the notice be issued to the opposite parties. The applicant shall take steps for issuance of notice under section issuance of notice to the opposite parties by speed post as well as by usual mode.
Usual service, maybe two of the respondents are West Bengal, Lordship. So maybe speed post
By
only.
speed post within 7 days from the date of this order, returnable on 23rd September.
Obligations.
Sixty-three.
My lord, this matter is settled outside the court, Lordship. So it has been settled in rupees 9,13,500, Lordship. Out of that, Lordship, we have already paid 3,23,500. Now we have to pay, Lordship, 5,90,000.
At what was the awarded amount? Original.
What amount is it? Six, 6,47,000, let's say. Along with 6% also.
And now at what?
So at the time of admitting appeal, let's say we deposited 50% of the awarded amount, let's say 3,23,500. Now the case has been settled at rupees additional 5,90,000. So total settlement amount is 9,13,500.
Yes. Anything?
I'm from 6 and 7, owner of the vehicle and.
Who is for the
Driver of the
claimant? Who is for the claimant?
I mean, has appeared, let's see, name has been shown, let's see.
No, but claimant has to be there. If it is.
Then let's see, it may be placed before the look at let's see.
No, we may fix another day. When is the local?
If they appear, let's see, advocate appear, let's see.
Who is appearing? Who is the counsel? Okay, heard Mr. K.K. Bhatta, the learned counsel for the appellant. Also heard Mr. What is the name?
J.A. Sikdar.
J.A. Sikdar, appearing for respondent number
6 and 7.
6 and 7. It is submitted by learned counsel for the appellant that this appeal has been amicably settled between the parties. And according to amicable settlement arrived at, the insurance company shall have to pay an additional amount of rupees 5,90,000 in addition to what has been already paid by the insurance company, that is rupees 3,23,500. Stop. In support of his submission, the learned counsel for the appellant has also produced a letter dated 3/8/2026 addressed to the Registrar General of this court by the Chief General Manager of Reliance General Insurance Company Limited. Let this said letter be marked as X and be kept with the record. However, since no one has appeared for the claimant today before this court, let this matter be listed again. 7 September. When is the Lok Adalat? 9 November. 7 September.
Obliged.
From your lordship, it may be adjourned for today, your lordship. Due to sudden demise of a family member of my senior, your lordship, he has to rush back.
And what is your name?
M. Nath.
And Miss M. Nath. You have informed the other side.
I'll inform
You
lordship.
inform. And Miss M. Nath, learned counsel for the appellant who prays for an adjournment on the ground that there is a bereavement in the family of engaged counsel for the appellant. She submits that she will inform learned counsel for the respondent regarding her prayer for adjournment.
It may be fixed on Tuesday, your lordship.
The prayer is according to law. Let this matter be listed. After 2 weeks on a date to be fixed by the registrar.
Much of course.
50. Item number 50. Mark off.
My lord, I made a calculation there.
It is agreed.
You also seen the
I
calculation.
have seen it, my lord. The interest portion may not be allowed, my lord, because the interest on future prospect is not applicable, my lord.
Okay.
The bond may be signed, my lord, because the. otherwise, my
With
lord,
an indemnity bond.
indemnity.
Okay, I'll allow it. Kunel is in the dictation. I'll allow it.
With indemnity bond, my lord.
Yes.
Along with interest,
The-
your lordship,
Not along with interest. This amount
with indemnity.
with indemnity bond.
Highly obliged, your lordship.
Item 64.
50. Yes.
It's complicated.
For office note dated 18/8. Service company.
Today you have had. Heard, yes, Mr. Bhatto.
Yes, service is completed.
Heard Mr. K.K. Bhatto. The learned counsel for the appellant. Also heard Miss
Yes.
M. Das appearing for respondent number 1 to 5. As well as Mr. D. M. Nath appearing for respondent number 6. The appearance of parties in this appeal is complete. The records of concerned MSC case has already been received. Hence, let this matter be listed after 4 weeks on a date to be fixed by registry.
Date may be fixed, not.
Give a
Otherwise
date,
it may be complicated.
17 November.
Obligement.
Item 65.
May I please be lordship? This is a condonation of delay petition, lordship, of 230 days. Delay will be condoned.
Yes, Mr. Paul,
I will no objection, madam.
you have no objection. Heard Mr. A. Agarwala, the learned counsel for the appellant. Also heard Mr. R.C. Paul.
Yes, for number one.
Appealing for opposite party number 1. This interlocutory application has been filed by the applicants under Section 5 of the Limitation Act, praying for condonation of delay of
230 days.
230 days in filing the connected MAC appeal, wherein the judgment and order dated 19/11/22 passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro at Gauhati, in MAC case number 1843/2020 has been impugned. The learned counsel for the applicant has submitted that the reasons for delay in filing the connected appeal has been stated in paragraph number
3, 4 and 5, lordship.
3, 4 and 5 of this interlocutory application. The learned counsel for opposite party number 1 has not objected to the prayer for condemnation of delay. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the reasons stated in the instant interlocutory application. After going through the grounds stated in the instant interlocutory application, this court is of considered opinion that the reasons shown by the applicants may be regarded as sufficient reasons which prevented the applicants in preferring the connected appeal within the prescribed period of limitation. As such, the delay of 230 days in preferring the connected appeal is hereby condoned, and this interlocutory application is allowed. Stop. The registry is directed to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by it.
Item 66.
Obliged, lordship.
In this case, there is a delay of 170 days. Lordship.
No objection, lordship.
Heard Mr. K.K. Bhatto, the learned counsel for the.
Lordship, talk of settlement is going on in this matter.
Okay. Heard Mr. K.K. Bhatto, learned counsel for the applicant. Also heard Miss, what is her? S. Patwari, the learned counsel for claimant, respondent number 1, claimants, as well as Miss M. Chaudhary, the learned counsel for respondent number 4. This interlocutory application has been filed by the applicant insurance company under Section 5 of the Limitation Act, paying for condonation of delay of 117 days in preferring the connected appeal. Stop. He submits that the reasons for delay has been stated
Para number 4
in
and 5.
para number
4 and 5.
4 and 5 of the instant interlocutory application. Stop. Ms. Patwari, the learned counsel for claimant respondent, submits that since a talk of compromise is going on between the parties, the respondent has no objection if the delay is condoned. Ms. Chaudhary, learned counsel for respondent number 5, also does not opposes the prayer for condoning the delay. Stop. I have gone through the grounds stated in the instant interlocutory application. After considering the said grounds, this court is of considered opinion that same may be regarded as sufficient cause which prevented the applicant in preferring the connected appeal within the prescribed period of limitation. As such, the delay of 117 days in filing the connected appeal is hereby condoned and this interlocutory application is allowed. The registry is directed to register the connected max appeal and list the same for admission.
And it will be placed before the coming local office after registering the appeal.
No, let it first come to this court. After a week on a date to be fixed by registry.
Item 67.
May I please, your lordship?
Yes.
My lord, this IA is filed for condoning the delay of 211 days in preferring the FAO, my lord. And there is a delay on the part of the petitioner appellant. And it is explained in page number 9, my lord. 9 and 9, my lord. CA applied for the certified copy, true copy of the order dated 19/12/24, and she got it on or before 15/7/25. Thereafter, she approached to the district legal service and entrusted her case for filing the appeal. And the Gauhati High Court Legal Service Authority engaged the legal aid council by appointment letter dated 23/7/25. And the council has consumed few days for preparing the appeal, my lord.
You are legal aid counsel.
Yes, my lord, legal aid counsel for the petitioner appeal.
Yes.
Lordship, do you have objections?
What objection?
If no proper cause for the delay has been mentioned, Lordship may kindly peruse over their petition, page 9 and 10. Sufficient cause for the delay, your Lordship, has not been shown.
What is the order which has been impugned in the connected appeal? Which order you are challenging?
I'm challenging, my lord, petitioner is challenging against the order dated 19/12/2024, passed in Miss Case number 43/2023. It is annexure 1, my lord, in page number.
What was directed by them?
My lord, in this case, in this petition, my lord, an ex parte order was passed in favor of the respondent, my lord.
Against you?
Against me, my lord. Thereafter, petitioner approached to vacate the ex parte order, and due to non-accompanying condonation petition, and the third petition was rejected, my lord. And thereafter, did she approach to the High Court, my lord, Honorable High Court. Your lordship, kindly see annexure 1 in page number 13, my lord.
Okay, we'll discuss.
It's a family matter dispute.
Heard. Miss B.R.A. Sultana. The learned counsel for the applicant. Also heard Mr. What is your name?
K. Goswami.
K. Goswami. Appearing for respondent number. Opposite party number 1. For whom you are appearing?
The lordship. Respondents for into both, all the respondents.
1 and 2. 1 and 2.
And my lord, the petitioner was not silently sitting, my lord. She approached to court by court, my lord. Before approaching to the sessions, district and sessions, just she approached to the Honorable High Court, filed a petition, WPC number. And that WPC was dismissed due to the void of merit. Because before that, the respondents has already obtained a succession certificate, my lord. And that certificate was obtained by order dated
Likha.
they have
This interlocutory application has been preferred by the applicant under Section 5 of the Limitation Act 1963, praying for condoning the delay of 211 days in filing the connected appeal, in which the order dated 19/12/2024 passed by the Court of Learned Additional District Judge in District Judge Dibrugarh in Misje case number 43/2023 has been impugned. The learned counsel for the applicant has submitted that the respondent number 1 had filed a succession case before the Court of Learned District Judge Dibrugarh, and same was registered as missed succession case number 22/2021, which was disposed of by passing ex parte order dated 15/6/2023. Where have you mentioned the reasons? In which paragraph?
Yes, my lord.
In which paragraph you have mentioned the reasons for delay? Reasons for delay.
Reasons for delay in paragraph, in page number 9, paragraph number 9.
Lordship, no proper reasons have been cited, and reasons such as delay in getting certified copy, these are not all valid reasons.
On which date order was passed?
Order was passed on 19/12/24.
When you applied for certified copy?
My lord, certified original copy was provided by the office to before 15/7/2025, my lord. And after getting the true copy, she has
When you have applied, on which date you applied for certified copy?
my lord, it is original copy, my lord, and the original copy is enclosed.
When did you pray for getting certified copy? When did you apply for getting?
My lord, there is not record, my lord, but it is on before 15/7, my lord, because in the 15/7/25, my lord, the petitioner approached to the High Court Legal Office.
No, that is not my question. The order was passed on 19/12/2024.
Yes, my lord.
It is.
On which date you applied for getting
It is
certified?
Applied for certified oblique true copy of the order dated 19/12/24.
When?
My lord, there is not a mention in, my lord.
Unless you mention it, how we will come to the finding that.
Because as per 15/7/25, it presumed that she approached after getting the true copy or either certified copy or true copy, she approached to the legal office, my lord. Because as per my record, it is 15/7/25 that she approached to the office. And sometimes in the court, order is shown as it is shown, but copy is very belatedly in the record, my lord.
When you are praying for condoning the delay,
Yes, my lord.
you have to show that you were diligent in applying the certified copy. You applied for certified copy within time, and then there was delay in furnishing the copy. You have only mentioned the date of receipt of the certified copy.
My lord, as the record is available, supplied by the office, it is only the true copy is provided, my lord. True copy of the order is provided. And it is only enclosed in the main appeal copy, my lord. It is the photos copies.
Oh, you may be legal aid counsel, but you have to inquire from the.
This this case is sent from Dibrugarh, my lord. Dibrugarh legal office to the High Court legal officer. So what is supplied by the office, and it is that's our supply.
Then how this court will decide in absence of all facts?
As the petitioner's legal form application form is available, my lord, so it may be considered that she may be got on or before 15/7, my lord. And from the Dibrugarh district to the High Court, maybe the time may be taken, my lord, for the petitioner.
Calculus.
Your lordship.
The learned legal aid counsel has, for the petitioner has submitted that the petitioner received the certified copy of the impugned order dated 19/12/2024 only on 15/7/2025, and thereafter being unable to pursue her case, she approached the District Legal Service Authority staff. Her case was referred to the Gauhati High Court Legal Service Committee, and the present legal aid counsel was appointed only on 23rd of July 2025. Thereafter, for preparing the memo of appeal, some time was consumed, and in the process, (211 days) of delay has occasioned. She therefore prays for condoning the delay. On the other hand, learned counsel for the opposite party, Putul, learned counsel for the opposite party has submitted that the applicant has failed to explain the delay occasion in filing the connected appeal. He submits that no proper reasoning, no proper explanation has been given for delay of 211 days in filing the connected appeal. He submits that the records would indicate that the present applicant appeared before the trial court in successions case number 22/2021. However, later on they defaulted, and as such, the succession case proceeded ex parte against her, against them. Stop. He further submits that even the application for setting aside ex parte decree under Order 9 Rule 13 CPC was filed, which was filed belatedly, was without any application for condonation of delay, and as such, the trial court rightly dismissed the said application where it's ordered it in 19/12/2024. I have considered the submissions made by learned counsel for both the sides and have gone through the materials available on record. Though there appears to be lapses on the part of the present applicant in filing the appeal within the prescribed period of limitation. However, considering the fact that the succession case was decreed ex parte, as well as also considering the fact that she has to take assistance of legal aid counsel and the process adopted by the district legal services authority as well as High Court Legal Service Committee consume lot of time. As such, a liberal and justice-oriented approach is taken in this case, and the delay of 211 days in preferring the connected appeal is hereby condoned. The registry is directed to register the connected FAO and list the same for admission after a week on a date to be fixed by it. This interlocutory application is accordingly dismissed.
So this.
Item 68.
Yeah, please, Your Lordship. Lordship, this is an application of condonation of delay of 72 days. Kindly peruse office note dated 18/8/26.
Yes. How many opposite parties are there?
3 respondents are there, Lordship.
I'm appearing for respondent of 3, my lord. On behalf of Mr. Yetsani.
Heard Miss S. Patwari, the learned counsel for the applicant. Also heard Mr. S. Sharma, the learned counsel appearing for opposite party number 3. On perusal of office note dated 18/8/2026, it appears that notice issued to respondent number 2 has been delivered to him on 12/6/2026, whereas notice issued to respondent number 1 was refused to be accepted by respondent number 1 on 11/6/2026. As such, the notices issued to respondent number 1 and 2 are held to be duly served. You are opposing
Maybe Kondo.
this interlocutory application has been filed by the applicant insurance company, by the applicant/claimant under Section 5 of the Limitation Act 1963, praying for condonation of delay of 72 days in filing the connected appeal. So the learned counsel for the applicant has submitted that the reasons for delay in preferring the connected appeal by the present applicant has been stated in paragraph number
3 and 4, Lordship.
3 and 4 of the instant interlocutory application. The learned counsel for respondent number 3, considering the reasons stated in the instant interlocutory application, has not opposed the prayer for condonation of delay. I have gone through the grounds stated in the interlocutory application, as well as considered the submissions made by learned counsel for both sides. The reasons stated in paragraph number 3 and 4 of the instant interlocutory application appears to be sufficient reasons which prevented the applicant in preferring the connected appeal within the prescribed period of limitation. As such, the delay of 72 days in preferring the connected appeal is hereby condoned, and this interlocutory application is allowed. The registry is directed to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by it.
Lordship, in this matter also talk of settlement is going on, Lordship. So the matter may be listed in the Lok Adalat.
No, after
Admission.
admission.
Item
69.
May it please your lordship. Lordship, in this matter, the IA is for condonation of delay of 86 days, my lord. As per office note dated lordship 9/6/2026, service is complete, my lord, but no one has filed any wakalatnama.
Miss S.E.
Murtaza.
Murtaza, the learned counsel for the applicant. On perusal of office note dated 17/8/2026, it appears that notices issued to respondent number 1, 2, 3, and 4 have been delivered to the addressee on 4/7/2026. Hence, the notices issued to the aforesaid opposite parties are held to be duly served. Since no one has appeared on behalf of any of the opposite parties to let this matter be listed next week. Listed on 20th.
Prior lordship, the interim was till today, lordship. Interim may be continued.
What interim?
Interim order stay is still returnable date, lordship.
let this matter be listed on 27th August. The interim relief granted to the applicants by order dated 22/7/2026 shall continue till next date. List accordingly.
Obliged.
I did one.
May it please the Lordship. My lord, the petitioner's matter, prayer for amendment was rejected. I have prepared a brief note, madam. So Lordship will kindly have a look at the note. Look, the petitioner, my lord, as a plaintiff, he filed his title suit 13 of 2022, my lord, for declaration of his right title interest over 14 bighas of land. And this 14 bigha, 1 katha 19 lessa is the Schedule A land. And out of this, my lord, 14 bighas, my lord, 9 bigha is the suit land. Now, my lord, on 26/7/2021, my lord, the defendant number 1 and 2, my lord, approached him and said that they had purchased the suit land from the defendant number 3, wide registered sale deed number 2367. Thereafter, my lord, the plaintiff inquired, my lord, with the circle officer, my lord, and came to know that
Yes.
that, my lord, the defendant number 3 husband, Ramesh Chandra Oza, my lord, had an illegal mutation. But the plaintiff is at page number, my lord, 16. It starts from page number 16. So, Ramesh Chandra Oza, my lord, had mutated the suit land in the year 1971. So, Lords will find at page number 16 onwards, my lord, at page number 18. So, at that point of time, my lord, the plaintiff thought that, my lord, on the basis of an illegal mutation, the defendant number 3's husband had transferred the land, my lord, to his wife, and after that, my lord, the defendant number 3, that is the wife of Ramesh Chandra Oza, had sold the suit land to defendant number 1 and 2. And on that basis, my lord, the plaintiff prayed for declaration of his right title interest. If your lordship will see the reliefs, my lord, cancellation of the sale deed number 2367, and also cancellation of the illegal mutation dated 26/1971, 8/10/1993 onwards, my lord. Now, my lord, in the what happened, my lord, the defendant number 1 and 2 filed written statement, but the suit proceeded ex parte against defendant number 3. In their written statement, my lord, if your lordship will see, they, my lord, for the first time, they said that the plaintiff had sold the suit land in favor of Ramesh Chandra Oza, that is the defendant number 3's husband, in the year 1969. Initially, we thought that there was an illegal mutation, but from their written statement, we came to know that there was a sale deed in favor of Ramesh Chandra Oza, that is the husband of defendant number 3. And subsequently, defendant number 3 had sold 2 bighas of land to the defendant number 1 and 2. That is in the written statement. Now, what happened, lordship will see the chronology, my lord. Is the second page of the note.
Yes.
So, on 25/8/2023 was fixed for evidence of the plaintiff. And 26/9/2023, it was fixed for cross-examination of the plaintiff's witness. Thereafter, my lord, this amendment petition was filed on 13/2/2024. Now, this amendment prayer was rejected only on the ground that, my lord, it was filed at a belated stage. That means after the trial commenced. And since it was fixed for cross of PWs, the application for amendment was rejected. Now, lordship will kindly see the petition at page number 25.
Yes.
Para number 1, that after receiving written statement from defendant number 1 and 2, the plaintiff came to know for the first time that there exists a sale deed bearing.
Now, what amendment you are seeking?
Well,
Cancellation of
one, two, yes.
sale deed.
Yes, challenge that sale deed, that much, madam,
Ramesh.
because that is the basic, madam, root of all the subsequent transactions, madam, and if we do not challenge that, madam, then it will become,
But
madam,
you came to know about that
only after the written statement. was
filing of
filed. Yes.
WS,
Yes,
even before framing of issues.
yes.
You could have challenged it
No,
earlier.
the thing is, Lordship, if your Lordship will see para number 3, my lord, that copy of the sale deed, my lord, was not produced. And so we did not have any access to the copy of the sale deed. So we applied for the certified copy that I have mentioned, my lord, on 23/11/2023. And we received the certified copy on 7/12/2023. And after that, my lord, on 13/2/2024, we filed the application, my lord. That was what, my lord, the reason behind the delay. It specifically mentioned, my lord, that defendants have deliberately abstained from producing the registered sale deed at the stage of production of documents during trial. Therefore, the plaintiff had to apply for the certified copy of registered sale deed and procured the copy on 7/12/2023, and the application was filed on 13/2/2024. So, yes, my lord, there was a delay, my lord, of around 2-3 months, my lord, but because of, my lord, situations beyond our control, my lord, that is why we could not make the appropriate application at an earlier stage. Now, my lord, yes,
Where is the impugn order?
yes, impugn order, my lord, is at page number 38. And the relevant paras are para number 4, 5 and 6 at page number 41.
What is the ground you are taking that you have not sold?
Yes, well, we want to challenge that sale deed, my lord.
On what ground you are challenging? There must be
That-
some
yes,
ground
that will be in
that
the,
it is a fake sale
Yes.
deed.
that will be in the proposed amendment.
Because
my
it
lord.
is your own sale deed.
They say that it is my sale deed, but
What you are saying?
at page number, my lord, 27, proposed amendment,
What is your stand?
that the actual fact is that the plaintiff never executed any such sale deed and the said sale deed is forced, fake, hence it
Okay.
should be declared as null and
Okay,
void.
you are
Forced,
telling
forced
the
deed.
force.
Yes. So, my lord, burden will be upon us, my lord, to adduce proper evidence to show that that deed was forced. And, my lord,
So why the trial court rejected your
trial
plea?
could reject it just because, my lord, it was filed at a belated stage, my lord, after the commencement of trial.
Where is the reasoning part?
At page number, my lord, 43, para 5. It was held again the trial in a civil court. Civil suit begins soon after the issues are framed, but in the said judgment, it was stated that if the trial court comes into conclusion that despite due diligence, amendment could not be prepared at the earliest stage, then amendment can be considered. The case of the petitioner clearly shows
What Order
non-existence.
6 Rule 17 says?
Yes,
What it says?
my lord, the proviso.
Proviso, what
Yes.
it says?
Well, the proviso says that provided that no application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial. So the due diligence part.
How the trial court has dealt with this?
Trial court, my lord. Para number 4, my lord.
Yes. Read it.
The very first prayer made by the petitioner that he came to know for the first time regarding existence of the sale deed bearing registration number so-and-so on the receipt of the copy of the written statement from the opposite parties itself shows that the petitioner was not vigilant about his own registered seal deed. Man, how can we be vigilant, my lord?
Because you are saying that
Yes,
it is
we are going to
forced.
deny it, my lord. Therefore, totally inverted logic, my lord. Therefore, there was a negligent conduct on the part of the petitioner in seeking amendment at the stage of cross-examination. Had we know about that sale date, we could have incorporated that in the plaint itself.
Because you are alleging it to be forced.
Yes.
And you are saying that you came to know
Yes.
only when the
Written statement was
WS was filed.
Yes.
And later on, only after procurement of certified copy, you.
Yes.
That is your reasoning.
Yes, my lord.
Whether that reasoning was addressed by the trial court. Read after that. Read after that.
Yes.
It is.
It is also stated by the petitioner that the opposite parties have abstained from producing the aforesaid seal deed, but it is pertinent to mention that the seal deed was apparently executed between the petitioner and some other person. So already came to a finding, manner that we had executed the deed. And it was therefore the duty of the petitioner to have brought such a document, which is vital in nature, at the very earliest stage. Further plea as regards to the fact that there was an error made in naming the parties properly and also showing the schedule of the boundary wrongly is another indicator that the petitioner was not at all vigilant while filing the suit. The proposed amendment will clearly change the nature and character of the suit, and already evidence is adduced by the petitioner and two other witnesses, and adducing of evidence as well as fixation of the suit for cross-examination of those witnesses is another indicator that the trial of the suit is instituted by the petitioner has already started. Thereafter, this judgment was discussed, and that's how it might not came to this finding. No, the thing is that, my lord, just by stating something will not help us, my lord. We will have to adduce evidence, my lord, and they will definitely be able to cross-examine us. We simply seek a window, my lord, to create this opportunity to say that, my lord, this deed is forced. Without that, my lord, we cannot adduce evidence, my lord. That much only, my lord. They will be able to file additional written statement, plus during cross-examination, they will definitely be able to put all these questions to us, my lord. We simply want to say that this deed is forced, and it may be cancelled. That much only, my lord. And I can place a judgment also, my lord, on this issue. In this case, my lord, it was a will. Citation to para number 13, 2024 SCC online. 2024 SCC online, SC 2615.
SC online.
2615. 615. So, Lordship will see para number 13.
Yes.
By way of amendment, what is sought to be done is to question the validity of the will, on the basis of which the defendant sought to have the suit dismissed, while also expanding the scope of adjudication of the suit to include movable property. It has to be then demonstrated that A, determination of the genuineness of the will is the necessary course of action in determining the issues inter se the parties. B, given the finding of the court below that the application was presented post the commencement of the trial, it could not have been despite due diligence presented prior to such commencement. Then 14, be that as it may, the overarching rule is that a liberal approach is to be adopted in consideration of such applications. Para number 15. In our considered view, the two aspects required to be demonstrated in accordance with the statutory language in the present facts do not stand on the same footing. The first issue will necessarily have to weigh over the second. So it says that, my lord, the issue regarding the genuineness of the will definitely have precedence over the question of due diligence, my lord. Why that follows, my lord? The scope of the dispute before us is limited to a procedural aspect. In the larger scheme, this dispute pertains to succession. If there is a will, it has to be honored. If one of the parties who will be affected by the will coming into effect challenges it on one ground or the other, the process of succession cannot go forward without determination of the dispute regarding the will. And all delays in judicial processes should be avoided and minimized to the largest extent possible, and should generally be and are rightly frowned upon. However, not in all cases can delay determine the fate of a suit. The defendant submits that the time gap between submitting the written statement to the suit and the presentation of the application seeking leave to amend is unexplained. If this argument of the defendant is accepted, the question of will shall remain undecided, or at best will be decided with great delay.
The trial, which has admittedly already commenced, would be stalled by way of a challenge to the framing of issues, which in turn would not be in consonance with the object of Order 6, Rule 17 of CPC, which is aimed at preventing multiplicity or multiple avenues of litigation subsumed under the umbrella of one dispute. Keeping in view the above, along with the fact that without determination of the question of will, any genuineness, the partition of the suit property would not be possible, we do not find any infirmity in the order of the High Court allowing the amendment, setting aside the refusal of the trial court to grant such amendment.
Otherwise, you are challenging 69 sale deed.
Yes.
Now,
Yes.
the question of limitation will.
No, it will come from the date of knowledge, madam.
Okay. Yes, Mr. Sikdar.
Madam. The first question is, my lord, the WS was filed on 28/11/2022.
28/11.
28/11/2022, Lordship will find at page 28. And they procured the improved sale deed on 7/12/2023. After 1 year. That is also recorded in the improved order.
Yes.
So after their stand is that they could know about the sale deed only after filing of the WS. And they took, my lord, about 1 year to obtain the certified copy of the improved sale deed. Then only they have filed the miscase for amendment. Yes, madam. And during this period, the case has been fixed for cross-examination of the evidence. So, my lord, this delay, my lord, is an inordinate delay. It cannot be, my lord, said that they have, despite their due diligence, they could not file in time. That plea is not acceptable, my lord, in this case. And
Just a minute. When did you apply for certificate?
But that
You find out
on 23/11/23.
23/11/23. So why there was delay for 1 year in filing?
Well, cross of one of the evidence was fixed on 25/8/2023.
No, you came to know about the.
Yes. Then, my lord, we
The
waited that they will produce the document at the time of issues and documents. They did not.
Now, why they will produce?
My lord.
Why they will produce?
My lord, during issues and documents, my lord, both the sides will have to submit their documents in origin as per Order 13, my lord. So we thought that, my lord, they will at least produce a certified copy or the original deed during the stage of issues and documents, but that was not done. So there was, I admit that there was some delay. 2-3 months of delay was there, but that does not mean that there was an inordinate delay. And if we had come, my lord, at the fag end of the trial, then also, my lord, it could be said that we have filled up a lacuna, my lord, want to try filling up a lacuna, my lord. But in this case, my lord, just, my lord, before cross of BWs, my lord, we made this application. How will it cause prejudice to them, my lord?
Yes, Mrs.
My lord, the land is in the occupation of the defendant, and that is their stand that there has been a mutation, illegal mutation. So illegal mutation is not illegal. There has been a sale deed, and this part of the sale deed, they have the knowledge, and it is their sale deed. The sale deed is their sale deed, and that ought to have been in their custody. And after the WS was filed on 28/11/2022, they could apply only on 23rd/11/2023 after 1 year. About 1 year. So how this can be, my lord, allowed in the meantime the case has been proceeded to the stage of cross-examination of the evidence. So, my lord, how they have exercised their due diligence. It's totally, my lord, heck stand, my lord, they on the other things, my lord, they cannot take up. when they have applied after 1 year. So their due diligence is totally missing in this case. So in that case, my lord, this case cannot be, their prayer for amendment is not allowable, my lord. And they have made some other prayer, that is, that means there has been some correction of the pleading name, correction of the name of the parties. Then, my lord, yes, my lord, the schedule correction of, they could not mention this proper schedule in the suit, my lord. So, my lord, these are, my lord, indicate that they have gross negligence. They have not exercised their due diligence. They have also committed mistake in page 40, my lord, in the important order that has been recorded. Kindly have a look at to the paragraph D, E, F. Why this type of mistakes? And you are coming for correction of this after 1 year of filing our WS. These are also, my lord, indicates that they are totally callous and they cannot be excused giving my lord, consideration of due diligence. No, there is no due diligence. So, my lord, the judgment of the Supreme Court that has been discussed in the judgment, I also want to refer, my lord, these two judgment, the Biddavai judgment and Koilar judgment. My friend is also taking up on judgment. So, my lord,
You are for this respondent number?
defendant number 1 and 2.
1 and 2. You purchased from 3.
Yes, my lord.
3 is the wife of Ramesh.
Yes.
Okay.
So, my lord, this two judgment I have mentioned the paragraph, relevant paragraph. That has been discussed in the imposed order also.
Huh? None. This is why?
Almost same points, my lord.
Para?
5, 6, 7, 8. 5, 7, 8.
What is your submission?
Please, your lordship. At the very outset, my lord, I am submitting respectfully that I had not received any summons from the trial court, my lord. Matter has been proceeding ex parte against me before the trial court, my lord. I have received the notice of this case, my lord, for the first time. I have not taken part in the trial before the trial court, my lord.
Matter is proceeding ex parte.
Ex parte against me, my lord. And earlier, my lord, our predecessor was pleaded as defendant number 3. And now, my lord, legal heirs of this is defendant number 3 have been included in this petition, my lord.
Who are you? Who are you?
Wife, son, and daughter of defendant number 3.
Okay. Of Ramesh.
Ramesh, my lord.
When he expired?
He expired long back, my lord.
Okay.
He expired, my lord, prior to filing of this suit.
Yes. What is your submission?
My lord, your lordship cannot see page 19 of this petition, my lord. Clear portion, my lord.
Most relevant is, my lord, page 20, prayer number D. Prayer number D, my lord, of the plaint. A degree for issuing proceed to the concerned revenue authority to cancel the illegal mutation by the order of CO Bhaskar dated 20th June 1971 and so and so so and so. My lord, this was the first mutation order dated 28th June 1971. This was passed on the basis of illicit sale, my lord. So prior to filing of this suit, they were having knowledge and information that this mutation order was granted on the basis of purchase and possession. In spite of that, they remain silent.
It was mentioned in the order.
Mentioned in the revenue record, my lord. Jamamanti.
Sale deed mention was there.
The mutation order was granted by virtue of Khoisa
Sale.
Dakol, purchase and possession, my lord.
Okay.
So they were having knowledge and information that this mutation order was passed on the basis of sale deed. They remain silent. Now, my lord, they are taking advantage that I have not filed the documents, the sale deed, my lord, defendant number 1 and 2 had not filed the document, and the document is still issued. My lord, those are better of past, my lord, now not applicable. Order 7, Rule 14 says the plaintiff is to file all the documents along with the plaint, not subsequently without leave of the court. Similarly, vice versa, my lord, defendant is also required to file or rely upon documents along with WS as per Order 1, Rule 8, Order 8, Rule 1, not subsequently without leave of the court. So whatever documents were there had been filed before the trial court by the contesting defendants. In view of no challenge of sale deed of 1968, this was not placed on record. They remain silent. So, my lord, there is no discharge of due diligence and efforts by the petitioner right from the day of filing of the suit till filing on the amendment application. This is my submission.
Heard. Mr. S. Das, the learned counsel for the petitioner. Also heard Mr. S. This is item number
1, madam.
A.R. Sigdar, the learned counsel for respondent number 1 and 2, as well as Mr. N. Anam, the learned counsel for respondent number 3. You all respondents. You are for
All three, my lord. DA to H.
3.1 to 3.6. This application under Article 220.
3A to 3F.
3A to 3F. Stop. This application under Article 227 of the Constitution of India has been filed by the petitioner Shri Ratiram Boro, impugning the order dated. What has happened to the suit now?
My lord, it has been stayed, my lord. There was an interim order, my lord.
Order dated 15/7/2024, passed by the Court of London, Civil Justice Senior Division, Baksa, in Miss J case number 2/2024, in title suit number 13/2022, whereby the prayer for amendment of the plain by the present petitioner was rejected. Stop. The facts, next para, the facts relevant for consideration of the instant CRP within bracket IO, bracket close, comma, in brief, comma, are that the present petitioner, comma, as plaintiff, had instituted a suit before the Court of London Civil Justice Senior Division, Baksa, praying for declaration of his right title and interest on the land mentioned in the schedule to the plaint, as well as for recovery of khas possession of the said land, permanent injunction, cancellation of mutation in respect of defendant number 1 and 2, and other consequential reliefs. Stop. In the plaint filed by the plaintiff, present petitioner before the trial court in the aforesaid suit, it was pleaded by him that he is the owner of a plot of land measuring 14 bigha, 1 kotha, 19 lechas, fully described in Schedule A to the said plain. It is It is further pleaded therein that on 26/7/2021, the defendant number 1 and 2, within bracket, present respondent number 1 and 2, inform the plaintiff that they have purchased the total how much land?
The suit land is 9 bigha 16 lakhs as well. That is the Schedule B land. But
Purchase.
they have purchased 2 bighas land.
How much land they have purchased?
In their written statement, they have said that they have purchased only 2 bighas.
And remaining?
Remaining, as far as the Schedule B was sold, to the defendant number 1 and 2, that is which is the suit land. Out of 14 bighas, 9 bigha is the suit land.
They have purchased. No. 9 bighas you have purchased.
No, 14 bighas, is the entire Schedule A land,
Yes.
Out of 14 bighas, 9 bighas is the suit land.
Suit land in the sense that this was purchased by 1 and 2 from
yes,
the.
yes.
Out of 14 bighas, 9 bighas sold to defendant number 3. And from this land, present defendant number 1 and 2 had purchased 4 bighas, 3 kata, 10 acres.
Yes. They have purchased 4 bighas.
3 kata and 10 acres.
3 kathas, 10 lechas.
Right, sale dated 30/10/96.
From
Defendant number 3.
defendant number 3 by executing registered sale deed number 236719/96.
This seal deed was executed by the wife of the original defendant number 3.
It was further pleaded therein that after the death of the
Ramesh Chandra.
Ramesh Chandra Ojha, his wife Bibi Bala. Bibi Bala's name was mutated in respect of the aforesaid land, and it is she who executed the sale deed in favor of defendant number 1 and 2. Stop. The said suit was registered as title suit number 13/2022. Stop. In the said suit, the defendant number 1 and 2 appeared and filed their written statement on 28/11/2022, whereas the suit proceeded ex parte against defendant number 3. In the written statement, the defendant number 1 and 2 took the plea that that the present petitioner had sold 9 bighas 16 lechas of land out of the suit land to one Ramesh Chandra Ojha by executing a sale deed on 3/6/1969, bearing deed number 4623/69. As well as, who is Sunil Boro?
Defendant number 1 matters.
As well as the wife of Ramesh Chandra Ojha, namely Bibi Bala, sold 2 bighas of land to the defendant number 1 by executing deed number 2952/2357. After filing of the written statement, the suit proceeded and the plaintiff's witnesses filed their evidence on affidavit, and next date for and 14 and 26/9/23 as well as 14/11/2023 was fixed for cross-examination of plaintiffs' witnesses. Stop. Thereafter, on 13/2/2024, the present petitioner had filed an application under Order 6, Rule 17 of the Code of Civil Procedure, praying for amendment of the plain by incorporating certain new prayers and also seeking amendment of some other inadvertent mistake which had crept in the plain. However, by order dated 15/7/2024, passed in Misje case number 2/2024 in title suit number 13/2023, the trial court had rejected the prayer for amendment. The said order of rejection has been impugned in this instant, CRP within bracket IM. Stop. Mr. S. Das the learned counsel for the appellant has submitted, learned counsel for the petitioners has submitted that the trial court had erred in rejecting the prayer for amendment of the claim by holding that there was lack of due diligence on the part of the present petitioner in seeking amendment of the claim so belatedly. So he submits that when he submits that the sale deed executed by a sale deed which is purported to be executed by the present petitioner in favor of Ramesh Chandra Ojha is a forged sale deed and the petitioner was unaware of its existence. He submits that it is only when the defendant number 1 and 2 had filed their written statement on 28/11/2022, wherein it was for the first time pleaded that the present petitioner had sold 9 bigha 16 lechas of land to the Ramesh Ojha, the petitioner for the first time came to know about the existence of the forged sale deed. Stop. He further submits that since the defendants have pleaded in the written statement that the present petitioner had already sold 9 bigha 16 lechas of land to Ramesh Chandra Ojha, he was expecting that the defendants would produce that document during cross-examination of plaintiff's witness. However, when same was not done, they
During
apply
issues and documents, man.
and
Documents this.
During issues and documents.
Yes.
Then it will go against you because issues and documents were fixed in the
Yes.
month of April.
Yes.
You applied in November.
Yes.
Okay. क्या लिखा? क्या लिख ले? Oh, aru ek line upar. He was expecting that during the not cross-examination, during the stage of framing of issues and submission of documents. However, when same was not done, he applied for certified copies of the sale deed number 4623/69 on 23/11/2023, and the said certified copies were furnished to him only on 7/12/2023, and as such there was a delay in filing of the petition for amendment. He further submits that the issue raised by the present petitioner regarding genuineness of the deed number 4623/69 is required to be decided for a just decision of the pending suit which was filed by the present petitioner. And as such, the trial court has erred in disallowing the amendment which was sought for by the present petitioner. He submits that while considering an application under Order 6, Rule 17 of the Code of Civil Procedure 1908, a liberal approach is to be adopted by the courts as held by the Apex Court in several of its judgments. He submits that the object of Order 6, Rule 17 of the CPC is to prevent multiplicity of the suit, multiplicity of the proceedings. In relation to those disputes which may be settled in a single suit. Stop. In support of his submission, the learned counsel for the petitioner. No, before that. He further submits that by allowing the said amendment, the defendants, within bracket present respondents, would not be prejudiced in any manner, as they would get ample opportunity to cross-examine the witnesses of the plaintiff as plaintiffs. Stop. He further submits that the plaintiff's witnesses are yet to be cross-examined by the defendant sides. Stop. On the other hand, Mr. A.R. Sigdar, the learned counsel for the respondent number 1 and 2, has submitted that the trial court has correctly held that there was lack of due diligence in seeking the amendment of the plain by the present petitioners. He further submits that as the trial has already been commenced and the petitioners have failed to show that the amendment could not have been sought for before commencement of trial in spite of due diligence. Hence, the trial court has not erred in any manner in rejecting the prayer for amendment. He submits that admittedly, it is apparent he submits that it is apparent from the pleadings made in the application under Order 6, Rule 17 by the present petitioner that they came to know about the existence of sale deed number 2367. The sale deed number
4623. 69.
4623/69 on 28/11/22 itself, when this present respondent number 1 and 2 had filed their written statement in the said suit. However, in spite of that, they waited till 23/11/2023 for filing certified copy of the said sale deed.
My lord, I maybe make one clarification, my lord. They have the sale deed, the proposed sale deed there, if they want to challenge, that was of the dependent number 3. That was that cannot be in my custody. And the dependent number 3, no notice was served. The dependent number 3. The case was proceeded against the ex parte against the dependent number 3. That point.
No, it is proceeding ex parte only after service of notice.
Notice was not received by him.
No, that is his claim.
So, my lord, my point is that since the dependent number 3 not appeared in the case, the question of producing the
yes.
deed in the during documents and issues is not possible. And I am not
Okay, understood. Kalika. Sale deed. He further submits that the prayer application for seeking amendment was also belatedly filed on 13/2/2024. That is more than 1 year, 3 months, more than 1 year, 2 months of the date when the existence of sale deed number 4623/69 came to the notice of the present petitioner. He further submits that since the sale deed number 4623 was executed by the present petitioner in favor of the original defendant number 3, namely Ramesh Chandra Ojha, the defendant number 1 and 2 were not supposed to have possession of the said sale deed. And therefore, the question of their submitting the said sale deed at the stage of documents and issues does not appear. He therefore submits that the trial court was correct in rejecting the prayer for amendment of the plain, which was belatedly made without due diligence on the part of the present petitioner. In support of his submission, he has cited a ruling. He has cited following rulings. Number 1, Kailash versus Nanku. Kailash versus Nanku, it deals with amendment also.
Yes.
Which para?
Well, paragraph 13. 1-3.
Kailash versus Nanko and others reported in 2005, 4 SCC 480. Next. Vidyabhai and others versus Padmalatha and another reported in 2009, 2 SCC 409. Who has given this last one?
I
Life,
have the letter, my lord.
life insurance.
2011 SCC 549.
And this life insurance,
I have written. I have written.
which para?
The guidelines one. It starts from para 7. 71.
Para?
71, my lord.
71. Petitioner Tatarweta Dindibu. Life Insurance Corporation of India versus Sanjeev Builders Private Limited and others. And the petitioner reported in 2022, 16 SCC 1. Next para. On the other hand, Mr. N. Alam, the learned counsel for respondent number 1, has also submitted that the trial court has made no error in rejecting the prayer for amendment on the ground of lack of due diligence on the part of the present petitioner. He submits that the respondent number 3 has not received any notice from the trial court and the suit is proceeding ex parte against her or
Against her, my lord.
against her. He further submits that the plea taken by the petitioner that they were waiting till framing of issues to see whether the respondents submits the sale lead number 4623/69 is not believable as according to Order 8, Rule 1, even the defendants have to submit the documents on which they are relying along with the written statement. He further submits that since the suit was proceeding ex parte against defendant number 3,
But possibly the legal heirs of defendant number 3 as well, ma'am. They were impleaded, thereafter notices were sent, then they did not appear. And
defendant number 3, as well as the legal heirs of defendant number 3, the question of their submitting the said documents does not arise. Otherwise, your submission is similar to Mr.
My lord.
Sigdar's submission.
Your lordship, I cannot take one more quote, my lord. 8 page, my lord. 27, your lordship, I cannot see. Page 27 of this petition, my lord. They have paid for insertion of prayer, para number 4B.
Okay.
In
Page
the
number?
proposed amendment, page 27, my lord. In main paragraph B, there is another paragraph 4B. This is their proposed amendment, my lord.
He further submits that apart from
Challenging the sale deed.
challenging the sale deed number
2369.
4623/69, the present petitioner have also sought for some more amendments, like correcting the name of Mr. Ramesh Ojha from Ramesh Ojha to Ramesh Chandra Ojha in the plain. Similarly, names of father of the plaintiffs from Gopi Boro to Gopinath Boro, as well as the boundaries of the suit land in the schedule given to the plain. He submits that these amendments have no connection with the sale deed, which,
One more amendment, my lord.
which one?
4B, my lord. 4B, page 27, my lord, 4B.
What is this?
The plot of land measuring 9 bigha, 16 lessas, bearing Dag number 4, Patan number 4, Ghoramana village, Moja Bizni, PS Salbari, district Baska, Assam, as described in schedule below of the plaint falls under tribal plates and blocks, as a sale executed between tribal and non-tribal is void. They intended to insert this without any explanation.
Sale deed. Stop. He further submits that the another amendment which was sought to be incorporated as paragraph number 4B in the plaint, namely the suit land falls within tribal belt and blocks, and therefore sale executed between a tribal and non-tribal is void ab initio, is also
This was well in existence prior to filing of this suit.
is what is your submission?
My lord, this was in existence prior to filing of the suit, but there is no explanation why he could not challenge this at the time of filing of the suit.
That's
No
a
explanation.
Consequential amendment, madam.
No amendment.
Sale
No,
deed, then
no
consequential
explanation.
amendment.
This fact was known to the petitioner even at the time of filing of the, even prior to filing of the suit. However, no clarification has been given why belated amendment was sought for, seeking incorporation of the aforesaid amendment. He therefore submits that the trial court has correctly rejected the prayer for amendment made by the present petitioner. In support of his submission, the learned counsel for respondent number 3 has cited following rulings. Pandit Malhari Mahale versus Monica Pandit Mahale and others, reported in 2020 11 SCC 549. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also gone through the rulings cited by learned counsel for both sides in support of their respective submissions. Dot, dot, dot. I am reserving the judgment.
Highly obvious.
Reserved.
Please, Your Lordship.
Yes.
Lord, this is a defendant's appeal against an order of injunction. Lord.
Injunction was granted.
Injunction was granted against us.
Against you.
Now, if Your Lordship has page 13. One, three.
Yes.
Now, Your Lordship finds Apurbo Sohoria, he happens to be the plaintiff. Now, he's suing his father, Khogen Sohoria, and his younger brother, Miganko Sohoria.
Okay.
Now, on the following page, at page 14, Your Lordship finds that he admits he's governed by the Dayabhaga School of Hindu Law at paragraph 4 at page 14, my Lord. Then at paragraph 5, he narrates how the property has come to the hands of his father.
What relief he has?
He has sought for declaration of right, title, and interest, and he says that his father cannot transfer it because his father has transferred a particular portion, gifted a portion of the property to the younger brother. So he sues for cancellation of the deed.
Okay. And father is not the absolute owner.
Father is the absolute owner.
No, what is his plea?
He says the younger brother may have prevailed over him, etc., etc. And he says that since I'm also enjoying portion of that property, so there should be an injunction. It's the issue otherwise is very small. So the question is, I am the absolute owner. We are covered by the Dayabhaga law. So long as I am alive, the succession doesn't even open.
Yes.
So on that basis, he files the suit, and he also obtains an order of injunction.
For not alienating the property.
From not alienating, transferring, and he runs a particular clinic from around 240 square feet of a 3-story RCC building, not to evict him. That, of course, my lord will examine. He's in possession, but all said and done, his possession itself is permissive, because as on date, I'm the absolute owner. I'm free to do whatever I want with the property.
Yes.
So, Lord, paragraph 5, he narrates how the property has come in the hands of his father. It was originally that of his grandfather and my father, Sandhiram Sohoria. And that came to devolve upon me, the defendant number 1. And then at paragraph 7, he says there's a hotel being run from that premises. That the defendant number 1 is running a hotel business, namely Hotel Madhuban and a medicine shop in the scheduled land and other businesses in the scheduled property. And thereafter, out of these...
Property was originally your grandfather's property.
My father's
Your
and
father's property.
plaintiff's grandfather.
And after death,
it devolved upon me. It devolved upon me. In fact, there was a partition among the other brothers and all. So eventually, so till there is absolutely no dispute that I eventually became the absolute owner.
Okay.
Now, of course, that then there are 2 more properties involved. So those are my self-acquired property, he again admits. Those are at paragraph 8, 9, and 10, my lord. And then paragraph 11, my lord, he says that he was in Bangalore for a while to pursue his education, and he claims to be in possession of a particular portion from where he says he's been running a clinic. That is at paragraph 11.
No, on what basis is claiming right over the property?
That is not understood, my lord. Because he doesn't really say that property he has a right by survivorship, etc. And he himself says that we are governed by Dayabhaga school of Hindu law, but he eventually claims title, Miller. Now, paragraph 12 is his allegation that that particular property was gifted to the younger son.
Gifted
Gifted.
by you.
By me. Paragraph 12.
And he has challenged this gift deed.
He's challenged this gift deed. So he says it is to deprive him from the property that the father has gifted it to the younger brother.
So what was injuncted in the?
Not to transfer, alienate, and not to disturb his possession. That operative portion your lordship finds at page 62.
You have already gifted.
I have already gifted. Now the defendant number 2 has become the owner. Now, my lord, I was competent to transfer it since it's my property. There's no concept of co-personary here. There's no concept of right by survivorship.
Where is the impugned order?
Impugned order, relevant portion begins from page 56. Page 50 otherwise is the order, my lord. Your lordship can skip over straight away to page 56. Or maybe your lordship can have page 58, my lord, after he discusses what is, after the learned court discusses what is prima facie case and all. Paragraph 15, my lord, that issue was specifically raised that the succession has not opened, so he's yet to inherit any right whatsoever. Paragraph 15, but the court decides to defer adjudication on that. Paragraph 15, however, in this regard, the court has taken its stand to postpone the issue raised by the opposite parties regarding the inheritance of property by son during the lifetime of the father under Dayabhaga law by indicating that the legality of the gift deed needs to be resolved at the first glance before resolving the issue of inheritance. Hence, at this stage, the court believes in maintaining the status quo and has reserved the above-mentioned issue to be decided on the merits in the original suit. The court finds that there is a strong existence of a prima facie case.
No, on what basis it is saying prima facie case is?
Well, the understanding of the trial court is perhaps that, well, because at page 56, what is meant by prima facie is being discussed. And it says that prima facie means just a bona fide claim, which absolutely there's no quarrel with that position. So therefore, the learned court says that whether a son would be entitled to inherit the property of a father who's still living, that issue will be decided during the merits of the case. That issue doesn't even survive because it's in black and white. I'm still alive, and how can there be an inheritance, my lord? And then, my lord, after that, the court holds that there is a strong prima facie case. And eventually injuncts both the defendants, the father and the younger brother, from transferring, selling, alienating, etc. Now, this is a commercial premise, my lord. I may have to take, as in the younger brother may have to take loan for running there's a hotel being run from the property, my lord. There are other business enterprises. Now, this sort of an order is bound to prejudice me. Of course, I must admit there's one portion that's 240 square feet that was given to him to run a clinic. Now, that possession also ultimately it's a permissive occupation.
Okay.
Now, and I have filed a written statement. The father has filed a written statement admitting that yes, I have gifted this property to my younger son. Now, he's as on today the absolute owner. He is free to deal with it in the manner he desires, my lord. And after the transfer has taken effect, my lord, the younger son would now be the absolute owner, and he again would be entitled to deal with it in a manner he desires, my lord. And to pass an injunction of this nature would amount to passing an injunction against the true owner. No, my lord, otherwise the issue is very small here. I reckon the suit itself is not maintainable because it's an obstructed heritage at the end of the day.
Okay.
Well, Lord, just to summarize, my lord, issue just 4 points, my lord. First of all, it's an obstructed heritage, my lord. So long as I am alive, the succession will not open. So therefore, there is the suit itself is not maintainable. It's not maintainable, and therefore the question of there being the existence of a strong prima facie case doesn't even arise, my lord.
Yes, sir.
That's number 1.
That means your submission is that there is no prima facie.
There is no prima facie case.
Okay.
Because it was admittedly the plaintiff's father's property. Father is free to deal with it, and father has already gifted it to the younger son, madam. Of course, there are other properties which are yet to be alienated as of now. So second point would be that ultimately at the end of the day, it is what the Supreme Court has time and again said, that there cannot be an injunction against the true owner, madam. So that is another principle which, in my respectful submission, the learned trial court has ignored, my lord.
Okay.
Thirdly, my lord, insofar as that doctor's clinic, dental clinic is concerned, my lord, that is admittedly my property. So his possession over that dental clinic would only be of permissive occupation, my lord. So going by the principle laid down in Maria Margarita also, a relative who is in permissive occupation, there cannot be an injunction at the behest of such a relative, my lord. And lastly, my lord, his possession, according to him, is confined.
Maria Margarita case you are giving.
Yes, yes.
Which para?
Paragraph 97, my lord. This is at page 34, my lord. Paragraph 97.
Yes.
Principles of law which emerge in this case are crystallized as under. Number 1, no one acquires title to the property if he or she was allowed to stay in the premises gratuitously. Even by long possession of years or decades, such person would not acquire any right or interest in the said property. 2 is concerning caretakers. Caretaker, watchman, or servant never acquire any interest in the property irrespective of his long possession. The caretaker or servant has to give possession forthwith on demand. 3 is important, my lord. The courts are not justified in protecting the possession of a caretaker, servant, or any person who was allowed to live in the premises for some time, either as a friend, relative, caretaker, or a servant. So relative is also included. Number 4, the protection of the court can only be granted or extended to the person who has valid subsisting rent agreements, lease agreements, or license agreements in his favor. 5 is again concerning caretakers, my lord, that we are not concerned. My lord, that principle of being no injunction against the coroner has been reiterated time and again. I'll just rely on one, my lord. This is Premji Ratan Se, Shah versus Union of India.
Para?
Paragraph 4, my lord, just below the dotted line. the sentence begins, last but three sentences, last but three lines, my lord. Does the defendants, as your lordship found it, towards the bottom, does defendant number 3 and 4 had no ghost of right, title or interest in the land acquired from the original owner Malibai, the said sale deed is void and the petitioners therefore cannot derive any interest under the agreement of sale to resist possession of the lawful owner, nor could the declaration sought for be given. The question therefore is whether an injunction can be issued against the true owner. Issuance of an order of injunction is absolutely a discretionary and equitable relief. In a given set of facts, injunction may be given to protect the possession of the owner or person in lawful possession. It is not mandatory that for mere asking such relief should be given. Injunction is a personal right under 41J of the Specific Relief Act 1963. The plaintiff must have personal interest in the matter. The interest of right not shown to be in existence cannot be protected by injunction. It is equally settled law that injunction would not be issued against the true owner. Therefore, the courts below have rightly rejected the relief of declaration and injunction in favor of the petitioner who have no interest in the property, even assuming that they had any possession. Their possession is only unlawful possession of a trespasser, and an injunction cannot be issued in favor of a trespasser or person who gained unlawful possession as against the owner. Pretext of dispute of identity of the land should not be an excuse to claim injunction against the true owner. So, and insofar as this concept of survivorship not being applicable in the case of Dayabhaga school is just placed two judgments, my lord. One of the Patna High Court and the one by the Honorable Apex Court. If your lordship has the Patna judgment first, para 13.
Yes.
Para 13, my lord. I have pointed out above that the parties were governed by Dayabhaga school of Hindu law. Under the circumstances, I would like to briefly summarize the law with respect to heritable property of a deceased Hindu governed by Dayabhaga school of Hindu law. It is well settled that the property of a deceased Hindu governed by the Dayabhaga law passes by succession and not by survivorship. This will include even his share in undivided property. According to the Mitakshara laws, each son acquires by his birth an equal interest with his father in all ancestral property held by the father. And on the death of the father, the son takes the property not as his heir but by survivorship. According to the Dayabhaga school, the sons do not acquire any interest by birth in ancestral property. Their rights arise for the first time on the father's death. On the death of the father, they take such of the property as is left by him, whether separate or ancestral, as heirs and not by survivorship. As such, there can be no co-parsonery in the strict sense of the word between a father and sons, according to the Dayabhaga law, so far as ancestral property is concerned. Then paragraph 15, my lord. According to the Dayabhaga law, the foundation of a co-parsonary is laid on the death of the father. So long as the father is alive, there is no co-parsonary in the strict sense of the word between him and his male issue. It is only on his death, leaving two or more male issues, that a co-parsonary is first formed. The effect of Hindu Succession Act 1956 is not to abolish or disrupt the Dayabhaga joint family, but the share of a co-parsonary in a co-parsonary property, as in the case of a separate property, will devolve by succession according to the provisions of the Act upon the heirs therein specified. In such a case, in case of a male Hindu governed by Dayabhaga school dying intestate and leaving ancestral property of which he was the absolute owner, such property will devolve by succession upon the heirs specified according to the provisions of Hindu Succession Act. So even if for a moment we hold that this property has flown from the grandfather, mother, first of all, your lordship is aware it requires 3 degrees to form a co-parsonary, and for Dayabhaga school, my lord, that stricter sense, so that concept of co-parsonary will not be there, my lord. So during his lifetime, he'll be the father would be within his competence to do as he desires, my lord. then that Supreme Court judgment of 2023, that was, of course, rendered in a slightly different context while dealing with rights of a Hindu female. But there also that concept of the Dayabhaga school of law was enunciated. That is paragraph 46, my lord. Under the, has your lordship found it?
Yes.
Under the Dayabhaga school of Hindu law, the daughters also got equal share along with their brothers. Under the Dayabhaga school, property is transmitted by succession and not by survivorship. In this school, a female could be a co-personal. So far as the Dayabhaga school was concerned, there was no concept of co-personal property, and every member of a Hindu family would hold property in his or her own right and was entitled to dispose of the property as he or she deems fit, either by gift or will. There is no concept of passing of property by survivorship, nor did the Hindu male in Dayabhaga school acquire rights to property merely by virtue of his birth. Consequently, so and so, so and so, so and so. So this is otherwise a very fundamental and elementary rule. I need not trouble your lordship with more authorities. So ultimately, so long as he admits that I am his father, that I am alive, and the property is mine, my lord, I continue to remain as a true owner. Your rights as a successor will not arise so long as I'm alive. And therefore, given the concept that there cannot be an injunction against a true owner, or there cannot be an injunction at the behest of a permissive occupier, so therefore this order of injunction, in my respectful submission, is bad in law for not having considered this moot issue while deciding the prima facie case.
Yes.
Postal from my lord. This suit was filed not for right title interest. This suit is now filed for declaration and cancellation of gift deed. The gist of the case is that the appellant is the owner. He got the property inherited, and it is admitted by the appellant that I am possessing the suit land since 2014. It is admitted by the appellant, and the suit land, and I am also possessing the suit land, and I am also giving my dental clinic over the suit land. That is also admitted by the appellant. During my possession, Your Honor, during my possession, the gift deed was executed. The gift deed was executed while I was in the possession.
No, but you are a permissive possessor.
Before, yes, my lord. I am a permissive. How the gift deed has been executed when I am there in the possession without my knowledge? How the gift deed has been challenged? That is a matter of trial court. The trial court will decide. And I was not asking for my right over the property. I was just, this suit is filed that during that when I was in possession, when the property was inherited by his father, by the appellant's father, and accordingly, he has instructed me, since I have done my BDS, and he has instructed me to open a dental clinic, and I'm running dental clinic over the suit property. And orally, he has gifted me this property. You can run your dental clinic over the suit property. So accordingly, I was running the dental clinic, and from the dental clinic, I'm maintaining my family. I'm running the livelihood of my family. But surprisingly, during this time, when I was in the possession, the appellant number 2 got gifted the suit land in his favor by appellant number 1. So it is not so from the submission of my learned friend, it looks like it's a matter of maintainability issue, Your Honor. Not because the suit is at advanced stage, Your Honor. It is in the stage of evidence stage. So now the trial court will decide
Your Honor. And if the injunction order is vacated right now, Your Honor, then I will be prejudiced, because I have invested my lakhs of rupees while maintaining, while giving the dental clinic, my lord. And if the injunction order is vacated at this point, then the very purpose of the suit will be infructuous, my lord.
No, but what is your basis on which you are claiming right over the?
I'm not claiming right, Your Honor.
You are claiming possessory right.
I'm not claiming possessory right. I am only claiming the gift deed which was executed during my possession is to be null and void. I'm not claiming any right. And I cannot claim right, my lord, since we are all governed by the particular school of law. And this is not a case of claiming right. This is not a case of claiming a property, claiming a share. This is a case, is only the challenge that how a gift deed has been done during my possession. When I was orally gifted by my the appellant to run over my clinic, and during my possession, during my peaceful possessions, and during my running of the clinic, the gift deed was executed. And everything is a matter of trial, my lord. And from their submission, it's a maintainability issue, my lord. And there are any other ways also to challenge the particular their rights. They could have filed a maintainability issues before the particular court. You know. It's not about injunction, interfering with the injunction. And if the injunction is interfered, I will be prejudiced. And the basic principles, all the three principles of granting injunctions were complied with in this case.
No, when you don't have any right over the property, how you satisfied the prima facie case?
I'm the elder son, my lord. I was permitted, orally permitted. Now the appellant has gifted in writing, but orally he has gifted me. And that is the part of the challenge in the before trial court, my lord. Because I was in possession, and still I am in possession. And any transactions or any transfer of immovable property, if particular person, if for the sake, my lord, if I am not there, if any other person is here, whether any kind of gift deed or sale deed could have been executed.
No, where is the bar?
Man, that will be in not a peaceful possession. The property will be that the other was when another person occupies the property, then there cannot be like first he has to get evicted, and then any transactions will take place.
Okay, what else? Yes. Whether gift deed can be executed
Yes,
without
but section 123 Transfer
without-
of Property Act is very clear.
without delivering possession.
Yes, it can be done insofar as the Hindus are concerned, because ultimately 123 says that it can be done by way of a registered instrument. So the moment a registered instrument has come into being, the gifts stands concluded and the transfer is complete. That's section 123.
Read 123.
For the purpose of making gift of immovable property, the transfer must be effected by a registered instrument signed by or on behalf of the donor and attested by at least 2 witnesses. Now, so far as possession is concerned, that is only with respect of movable property. If I may read that, for the purpose of making a gift of movable property, the transfer may be effected either by a registered instrument signed as aforesaid or by delivery. Such delivery may be made in the same way as goods may be delivered. So insofar as immovable property is concerned, delivery is not a option. Now, my lord, that oral gift submission, your lordship will not find any pleading to that effect regarding oral gift, and in any case it is not sustainable because oral gift of immovable property is not permissible unless that concept of causa mortis in Mohammedan law. And it is not fixed for evidence, my lord. In fact, we have already raised the issue of maintainability. Proceedings in the suit have been kept at abeyance as far as my instruction goes, because there is a petition under for rejection of plaint, my lord.
That is pending.
That is pending. That is pending.
Okay, heard.
And my lord, if that is petition is pending, then the trial court will examine whether the suit will be maintainable or not.
That
And even
We are only concerned with the injunction.
injunction, if it is vacated, I will be prejudiced. my lord.
Heard Mr. B.D. Decker, the learned counsel for the appellant. Also heard Mr. What is your name?
That's all.
S. Sharma, the learned counsel for the respondents. Hearing concluded, judgment reserved. I am reserving the judgment.
And just one clarification, that possession is only in respect of 240 square feet. There's one clinic there.
Yes, that you have mentioned.
In fact, I have said I have established it for him. That's in respect of 240 square feet in the first floor of a G+3 building.
I am his son, my lord, and it is his duty to establish me. It is a fact.
So long as he's a minor.
You are his son, but he is the owner of the land. Okay, wait for the judgment.
Obliged.
Ajab.
May it please, my lord. The petitioner is the plaintiff in the title suit, seeking injunction against the respondent, who are the landowner of the petitioner. The landowner, that is the respondent, wanted to disposes the plaintiff, that is the petitioner. Therefore, the petitioner.
Tenant.
I'm the tenant. The plaintiff in the title suit. Therefore, the petitioner filed a suit for seeking declaration for injunction, and according to the interim order accordingly the interim order was passed. And after passing of the interim order, they disposes the petitioner by hanging a lock at the door of the premises. Therefore, due to subsequent development, the plaint was required to be amended, and an amendment petition was filed to that effect, seeking necessary amendment in the plaint as well as in the relief. But the learned trial court below has rejected the petition against, and therefore we have filed this civil revision petition.
Where is the
And
impugn?
impugn order is in page number 38. My lord, if allowed me to read.
Yes.
By petition number this, the counsel of the petitioner has prayed for an adjournment to conduct the hearing of the petitioner is out of session. I have pursued the petition, but none has appeared in the petition stands rejected since the ground is not satisfactory. The instant miscase has been registered on the strength of the petition by number this filed by the plaintiff petitioner under order 6 rule 17 read with one for an amendment for amendment of plaint. I have thoroughly gone through the contents of the petition, wherein it is submitted that the plaintiff sought for a decree for permanent injunction against the defendant, restraining and prohibiting him and his men, agent, etc., for evicting the plaintiff from the suit room and premises, and from the closing the door under lock and key, and also from disconnecting electricity therefrom till evicted with due process of law along with other relief. The plaintiff also filed an application on wide miscase number 3519 under order 39 rule 1 and 2 read with 151 for grant of temporary injunction, in which this court, by order dated 11/2/2019, passed an ad interim order restraining and prohibiting the defendant opposite party from evicting the plaintiff from suit room, from putting any lock on the doors and the suit room, and from disconnecting electricity connection of the suit room until further order of the court. But on 12/2/2019, when the petitioner went to open her restaurant, she found the main door of the room and the main entrance gate was locked by the defendant. In the meantime, the plaintiff also filed one petition under section 151 of CPC directing the opposite party to remove the lock. But the said miscase was dismissed by this court. The plaintiff filed appeal 05 of 2019 before the Honorable Court of Civil Judge Senior Division at Tejpur, wherein it was ordered to maintain status quo over the suit premises till the learned trial court finally adjudicate the dispute in title suit 14/2019. During the pendency of the suit, the defendant illegally put lock on the suit room and the main entrance gate. Hence, the plaintiff sought for a relief of permanent injunction with mandatory form, restraining and prohibiting the defendant and his men, agent, etc. for evicting the plaintiff from the suit room, and restore the possession of the plaintiff by breaking open the locks of the suit room and entrance gate, and has also prayed for amending the plaint by inserting certain relief, such as relief of restoration of possession of the plaintiff. The opposite party also has filed his written objection, stating inter alia that admittedly the cause of action of the proposed amendment arose on 12/2/2019, and therefore the relief claimed by the proposed amendment is barred under law of limitation. The plaintiff has been proceeding with the suit since the year 2019 without praying for any amendment for the last 6 years, which shows sheer lack of due diligence on the part of the plaintiff. The proposed amendment is totally unnecessary to determine the real controversy involved in the suit. The defendant, in his written statement, has categorically denied the landlord-tenant relationship between the parties at the time of filing of the suit. The proposed it will completely change the nature and character of the suit. Under such circumstances, the opposite party has.
When you file amendment petition?
We have filed the petition in the year 2023.
On which date you have filed?
Just.
July 24th.
24 July, right? 2023.
24.
It is 23rd of July to 2024. It is in page number, my lord, 26.
No, continue reading.
The plaintiff has been proceeding with the suit since they in the year if the proposed amendment is allowed, it will completely change the nature and character of the suit. Under such circumstances, the opposite party has prayed for dismissing the application filed by the plaintiff. None appear to conduct hearing of the petitioner's side. I have heard the counsel of the opposite party who stated that the petitioner plaintiff has been delaying the matter indefinitely as she has nothing to lose, since there is a status quo order pertaining in the suit property. On the other hand, the defendant has been suffering huge financial loss as his property is remain unused. The counsel submit that the amendment sought for is an afterthought of the petitioner to further delay the matter, and if the amendment is allowed, it will completely change the nature of the suit, bringing it under section 6 of specific relief act. The petitioner plaintiff does not have any case to pursue as reveal from the order dated 2019, passed in Miss Case number 35, 2019. The council further stated that that by the order dated 12/3/2020, the Honorable Appellate Court in Miss Appeal number 5 has directed the trial court to dispose of the instant title suit within a period of 1 year from the date of passing of the order, which means the case should have been disposed by 12/3/2021. Yet the plaintiff has been dragging the matter by filing this or that petition. Under such circumstances, the council prayed for dismissing the amendment petition. The council further stated to case laws, Honorable Justice, this, and I have further gone through the record of the connected title suit 14 of 2019, which is a suit for permanent injunction. I have also pursued the plaintiff and WS meticulously to arrive at a just decision. It is found from such perusal that the suit was instituted back in the year 2019 and the same has been stagnating in the stage of preliminary hearing by the plaintiff, and the issue have already been framed back in the year 2019, and after around 5 years this instant petition has been filed by the plaintiff seeking amendment for adding a different relief of recovery of possession on the ground of subsequent development. However, plain perusal of the petition shows that the cause of action for seeking such relief arose in the year 2019 itself, but the plaintiff sat in silence for long 5 years, and thereafter she came up with the instant petition seeking amendment in order to incorporate the relief and certain other paragraphs. Now, the basic principles for allowing amendment of pleading in the light of Order 6, Rule 17 of CPC are: the amendment sought is necessary for the purpose of deciding the real question and controversy between the party. The amendment sought will not cause prejudice to either party. The amendment sought will not change the nature and character of the suit. Thus, there is no dispute that an amendment of pleading can be allowed if the amendment sought for does not change the nature and character of the proceeding in a given case, and or the amendment sought for would help in resolution of the real controversy in a suit. Coming back to the matter at hand, it is seen that the cause of action for seeking the proposed relief arose in the year 2019. Also, the relief of recovery of possession is governed by Section 6 of Specific Relief Act 1963, and the limitation period is 6 months. Further, if the relief is incorporated by way of amendment, the nature of the suit shall definitely change. For the avowment of the petition itself shows that the plaintiff has approached the court for amending the plaint after around 5 years, even though she was all aware about the alleged disposition all along. The Honorable Supreme Court, in the case of this, amendments that change the nature of the suit or introduce a new cause of action foreign to the original plaint should be disallowed. However, amendments seeking additional relief based on the fact already pleaded in the plaint should ordinarily be allowed. In the matter at hand, the petitioner is silent about the delay in approaching the court with the amendment petition, which is brought after a long gap of 5 years. The trial has already started in the case, as the Honorable Appellate Court has directed the court to dispose of the matter by March 21. The provision to Order 6, Rule 17 of the CPC has made it clear that no application for amendment shall be allowed for the trial has commenced unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial. The due diligence on the part of the plaintiff as required in Order 6, Rule 17 is absent in the matter at hand, since the alleged disposition of the plaintiff happened back in the year 2019 and plaintiff failed to approach the court in due time. If the amendment is allowed at this stage, this will definitely change the nature and character of the suit. Moreover, the amendment is not necessary to decide the real question and controversy. In view of the discussion made herein before and considered the facts and circumstances of the matter at hand, the court is not inclined to allow the prayer of the amendment of plaint at this belated stage and its disposal. So the delay portion, there are four grounds where we have challenged that in case of delay, in case of changes of cause of action, this is hardly relevant and not explaining delay. If it is so that the missed case were filed in due course of the pendency of the suit and the suit was in abeyance, and later on for filing of substitution petition because the defendant predecessor of the defendant was dead, and therefore substitution petition was filed, and after reviving the case, the main suit, this amendment petition was filed, and that is why the delay was
No, I'm not getting you. You were allegedly dispossessed on 12/2/2019. And
Yes.
you filed the amendment application on 23/7/2024.
Later on, because my lord, because again this appeal was an appeal was also filed
The appeal was regarding the injunction matter.
Injunction matter, and the the title suit was in abeyance at that time, and after
Hence why stay was granted.
stay was granted, and they have also filed an objection on that ground, and that is why again on
Where is the stay?
the stay was granted. It is in the order itself.
Which order?
In page number 39. Under Order 39, Rule 1, this was also filed for grant of temporary injunction in which this court-wide order dated this passed an interim order restraining and prohibiting the defendant.
That is a separate issue. But the suit was pending. Was there any stay of suit?
There was no stay
No
or
stay.
stay for any
You
suit.
could have filed.
But they have filed an substitution petition during that period.
That is also a separate issue. But suit was alive.
But
You could have filed an amendment because your amendment has nothing to do with their substitution application.
No, my lord, when the substitution petition was filed, the main suit was in abeyance. And
Where is the order?
my lord,
Where is the order? How many defendants were there?
there are two defendants.
Who died?
The predecessor. The predecessor of the defendants. That is the father of the defendants.
Originally, how many defendants were there?
There were one defendants and defendant. After the death of the original defendant, the substitution was brought before this the trial court.
When?
In the year.
When the original defendant died?
My lord, the substitution was filed in the year.
When the defendant died?
The defendant died in the year 2019, June.
And when substitution petition was filed?
March 16, 2016.
You are mixing up everything.
From their
One-
application, it appears that he was alive in the year 2024 also.
No, one of her submission is that as
The predecessor-
suit was not kept
That
in
is
a.
not such order. And it is not pleaded in their petition also, and nothing has been annexed here also.
The main suit was alive till 27/9/2023. September 27th, 2023.
It was
This, it was
progressing.
alive.
And
I don't-
you could have filed your amendment petition because cause of action arose in the year 19.
But my lord, delay of filing amendment petition is not a ground because there is already, we already have a judgment of Honorable Supreme Court in this regard. And because the Specific Relief Act, the section 5 and 6 of specific relief act has a difference between these two, because if we are before the within this 12-year of possession, then we can file at any time because there are judgments on this ground.
Show me.
These are the two. In AIR 1968 C 1165, in this case, the overruled part, if my lord may allow me to read out.
Which para you are relying?
The first para, the provision overruled part. Near Service Society Limited versus KC Alexander.
Yes, which para you are
The
relying?
first para, provisions of sections 8 and 9 of Specific Relief Act.
You are referring to head notes.
Head notes. The below the head notes. The paragraph below the head notes. 1911 ILR 33. All 19.
You come to the paragraphs, main body of the judgment. Which para you are relying?
My lord, the first para below the headline, that is the
No,
overruled
don't
part.
refer to head notes. Read the entire judgment and refer the.
But this portion has relevant of this in this ground. This have relevancy in this portion.
No, the head notes are editorial.
It's not head note, it's the overruled part.
This is head note by the. It must be there. It must be there inside the judgment.
Inside it, the matter is little different, so it cannot relate to this to our case. So that's why I was just going to read the head note to just make the difference between the section 6 and section 5. The definition is already there. If my lord may allow me to read, then I may.
Read it.
So
you have no, it appears that you have not gone through the judgment.
Judgment is not relevant because.
Have you gone through the judgment?
Yes, my lord, but I could not find any.
You could not find. Then how can you rely that judgment?
Because the portion, it talks about the specific.
From where this has come? This head note has come from the judgment itself. Somewhere it must be there in the judgment.
My lord, but my lord, I couldn't find anything related to this in this judgment.
And how can you rely that judgment?
Okay, my lord, we have other judgments too, if my lord may allow.
Yes.
In this Usha Devi versus Rizwan Ahmad, in this judgment, para 2, the appeal is directed against the order dated July 13, 2006, passed in the High Court, non-speaking order. And the High Court dismisses the writ petition and affirmed the order passed by the trial court, which in turn had rejected the appellant petition under Order 6, Rule 17 of the CPC for amendment of the suit property as described in the schedule of the plate. Now, para 3. The defendant respondent filed their written statement in which objection was especially taken to the description of the suit property as given in the plaint. On behalf of the respondent, it was stated that the area of the land that might possibly be the subject matter of any dispute was much smaller, and the plaintiff has described properties lawfully belong to them as the suit property. No rejoinder to the written statement was filed on behalf of the plaintiff, and on the basis of the pleading, issues were framed. Thereafter, the pleading in the suit remained in abeyance, but the appellant plaintiff filed a miss petition under Order 39, Rule 2A, read with Section 151 of CPC for alleged breach of an interim injunction earlier granted in her favor. So this is the thing, and rest I will not read because it is not relevant. But if my lord may turn page para 9. Para 9. The
What
last,
you want to emphasize? What you want to emphasize? Which?
I just want to bring before this honorable court that delay is not a is hardly matters. Delay on this ground hardly matters, because and the cause of action, changes in the cause of action is also not a ground for rejecting the application.
Okay, yes, Mr. Orchestra.
Lordship, there is no infirmity in the impugned order. If I may take a lordship the plaint for a while, Lordship. It is at page.
Be short.
Yes, I've just, Lordship has considered that cause of action of the suit as per paragraph 8-9 of the plaint on 31/1/2019. Original cause of action. And the suit is for injunction simpliciter. Next, prayer at page 14, Lordship finds that the first prayer is for degree of permanent injunction against the defendant restraining and prohibiting him and his managers, etc., from evicting the plaintiff from the suit room and premises described the schedule will, and from closing the doors under lock and key, and also from disconnecting the electricity there from till evicted due process of law. The law is settled that in suit for injunction simpliciter can be filed if the rights are admitted. Rights should be.
Yes.
So here they have said they are tenant. We have filed written statement. And in the written statement, from the written statement, it will be clear that the tenancy was terminated much prior in the year 2018, and she has, at page 20 of the written statement, Lordship, last part, I am reading a few lines. Finally, by in the last week of February 2018, the plaintiff handed over possession of the suit room and premises in favor of the defendant by paying the rent till the month of January 2018 and electricity charge till last week of February 2018. While handing over possession, as such, the plaintiff left some furniture in the suit room and premises, promising to remove those within a week by her. Due to leaving some furniture, as such, the suit room is kept under joint lock of the plaintiff and the defendant. That is one of the lock of the door put by the plaintiff and took the key of the same by herself, and another lock put by the defendant, the key of which is retained by him. So this is the factual position. There is no tenancy surviving, and there is no prayer for declaration of tenancy right also. It is a suit for injunction simpliciter. Now, cause of action, what has been proposed in the amendment application, it is 12 to 2019. We put lock and key, etc. And there are several amendments. 6, it is in paragraph 10, it is 10A, 10B, then 12. Many amendment has been proposed with a prayer for recovery of possession. This is restoration of their possession. Now, when there is no relationship of landlord-tenant, we have denied it. Had it is admitted this, then they had a case. No, we did not admit it. So there is no tenancy right. The right is not admitted that they are our tenant. So suit for injunction, they have filed originally. Now they are saying recovery of possession. Possession should be recovered. they have been disposed, but whereas there is a joint law. There was a joint law. Therefore, change of cause of action, what they are trying to say, and prayer is different. It cannot be made under the garb of subsequent development. One decision would, Lordship,
Otherwise, the trial court held that
yes,
the relief sought for by the plaintiff is under section 6 of the specific relief act.
yes, they are
And
disposed.
therefore, there is a question of limitation of 6 months.
6 months over 5 years, it is apparently 5 years. There is a lack of due diligence.
That is also one of the ground for
Yes.
rejection.
Apparently, there is lack of due diligence. 5 years is enough, and our specific stand is that
What cases you are relying?
Lordship, two cases, it is. Sorry. Only two paragraph regarding cause of action. Now, injunction amendment, Lordship, of plaint and amendment of written statement are two different. Amendment of written statement can be allowed at any time. But for amendment of plaint, there is.
In this Usha Bala Sahib
Usha Bala
case,
Swami-
which para you are
Top
in?
20 Lordship.
And in other case,
In other case, same Ushabana was has been relied upon.
para?
Para 24. 24. Which says the general principle that amendment of pleadings cannot be allowed so as to alter materially or substitute the cause of action or the nature of claim applies to amendments to the plaint. It cannot be allowed.
Okay.
My lord, that is what I was trying to present before this court, that in this order it is written in the right is only restricted to possession only in a suit under section 4 of the specific relief act, but that does not bar a suit for prior possession within 12 years, and title need not be proved unless the defendant can prove one. The present amended Article 64 and 65 of Limitation Act brings out this difference, and Article 64 enables a suit within 12 years from disposition for possession of immovable property, property based on possession and not on title, when the plaintiff, while in possession of the property, has been dispossessed. Article 65 is for possession of immovable property on any interest therein based on title. The amendment is not remedial but declaratory of the law. That is what I was trying to focus on this judgment. Because section 6 and section 5 both have this difference. 6-month limitation is only prevailing on that.
No, what I was mentioning that you are citing the.
I'm just citing the definition of this.
No, you were citing the head notes. You are unable to point out which paragraph of the judgment relates to that head note, which indicates that you have not gone through the judgment.
But in the later judgment also it is given.
No, I am not going to later judgment. I am discussing about this judgment. When you are assisting the court, you have to assist after full preparation.
But the other judgment also has some light on this. That's why.
Okay, I'll go through the judgments. I have taken note of that. Heard Miss, what is her name?
Aroy.
Aroy, learned counsel for the petitioner. Also heard Mr. S.D. Purkasta, learned counsel for the respondent, sole respondent.
Two respondents.
Respondents. Hearing concluded, judgment reserved.
No bless.
Hello, today, due to paucity of time, your lordship may not take up item 62 admission matter, supplementary admission. May I pray that your lordship may take up tomorrow, my lord, my plea, subject to your lordship's convenience, my lord.
What is the urgency?
In fact, my lord, the collateral proceeding of the bank is going on in respect under Surface Act. So that is the, my lord, urgency.
62 is the fresh item,
Fresh item, my lord.
day after tomorrow.
My lord.
62 day after tomorrow.
My lord, I can see, lordship, that is 2011 matter, lordship. May I pray for a date, lordship? Hearing day,
Then
lordship.
date will be,
I can see, lordship.
date will go to November. It will be shown as leftover. The registry will give dates in leftover.
Number 5.
For admission only, MSAP lordship.
Only for admission.
Enhancement
I have
lordship.
no, I'm the opposite party respondent. I have no objection to admit the appeal.
For
Item number
enhancement
5.
only, lordship.
I'm called for the record.
No. All leftover matters will be decided by registry.
Well, at least in the.
Otherwise there will be no end to the list. There has to be some end.
Well, maybe list on the net.
Friday, lordship.
No dates by the.
Or Monday.
It will be listed by registry, shown as left.
If it is admitted simply and.
It will be admitted, but wait for your turn.
Okay, lordship.
Today you are unlucky.
Much of that.